Item number 1, the writ appeal number 375 2018.
The appeals are allowed. No orders.
31 of 2019.
The appeal is dismissed.
Gratefully, Lordship.
Number 3.
None appeals, both dismissed.
Item 4.
Again, none appeals dismissed.
Item 5.
Item 5 matters. I am 3 matters, 1 week accommodation matters.
I see. All right. At the request of Mr. Mahapatra and counsel for the appellant. Let's go.
Item 6.
None appeals dismissed.
Item 8.
Yes, my lord. My lord, I am on behalf of Mr. Man.
Item 7 is not.
Not raised. Right. No instruction. Estimate.
My lord, on behalf of Mr. Man, he is unable to, he is suffering high fever.
This is an old matter, sir. Very old matter. We'll pass it over if you want to argue, but
Kindly take on next week.
no. Here is your paper book. You should bring your paper book, sir. We'll pass it over. Ask your senior to bring the paper. Take the paper book from your senior, come and argue it. This is one chance for you. All right.
Item 9.
May I please your lordship, my lord. This writ application was dismissed on
What's the main matter about?
my lord. Main matter is my lord. The direction be given to the collector Jaspur to consider their
All right. For the
written
reason
test.
stated, the application is allowed. The order is recalled. 4/8/2022 is recorded. And this writ petition civil 14693 is restored to 5. This is some IFL on shop.
My lord.
This main matter was
Yes,
about objection to the opening of an IMFL on shop.
Yes, my lord.
So I don't know this. There must have been a no. What is the proof of this?
Yes.
Where is it?
The first is there must be a proof of delivery of this objection, and that is should be within the period prescribed in excise rules.
My lord, my application that is annexer.
No, but is this the authority for a non-shop objection? It is to the collector. The objection is to the collector.
My lord, collector.
Eventually, it is to be
Mr.
collected.
Mahanti, Mr. Mahanti, you see page 10.
My lord, the
That is
brief
what
copy is not with me. If that is there, that must be there.
And I received a PR section collectorate, Jajpur.
No, but for on-shop objections, representation is not the route, right?
No,
There's
no,
a public notice.
that has to be a
Public notice and a proper objection to the notice.
To the public notice, objection has to be filed.
Public notice was issued, my lord.
What is the date of the public notice?
My lord, that is date was 26/4/2022, my lord.
How many days within what?
15 days.
Because that is the objection should be filed on 2/6/2022, my lord. As per the annexure 1, page 9, my lord.
How is that? How does 15 days from which date are you calculating?
My lord, they have mentioned in their notice, my lord. That
What's the date of the notice, sir?
My lord, the date of notice is 26/4.
This can't be the public notice. This is some Gangadharpur Gram Panchayat.
No, my lord, that is noticed by the
Public notice in Form 8. That is a prescribed
This is not
form.
the public
My
notice.
lord, this notice has been published by the Sarpanch, my lord.
That is not the notice,
No,
sir. When they open an arm shop,
My lord.
there is a notice, is a form in which notice is published.
Inviting public objection.
My lord, invite and public objection, my lord.
At page 9, third sentence that says that excise department has published it on 19/5/2022 in Odia.
May I suggest one thing to my lord? Lordship may direct if the objection of the petitioner is within the time prescribed under the public notice, then it will be considered in
All right,
accordance.
counsel with the petitioner. You said this writ petition has been restored by virtue of an order passed today in CM appeals also. The grievance of the petitioner is that their objection, or the petitioners is that their objection to the public notice regarding issuing an on-shop license in favor of respondent 4, party number 4 has not been considered. You see, in the event that such objection has not yet been considered, the collector will issue notice to the petitioners as well as respondent 4, and after giving them a hearing, pass a reasoned order on such objection.
Provided the objection is filed in time.
Yes. Pass a reasoned order not later than 6th February.
Obligation.
The order be communicated to the parties within a week.
Obligation.
Item 10.
My lord, item 10 may kindly taken up along with item 80 up to the list, to the supplementary list.
All right.
Item 11.
Item 11 permitted to withdraw with the liberty to face if fresh cause of action arises.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh pleading. If any cause of action survives, dismissed is withdrawn with liberty spared.
Obliged.
Item 12.
My lord, appearing virtually, my lord. My lord, similar matter, your lordship have issued notices on writ and also stay. Also, your lordship issued, my lord. My friend is there in the court, my lord. SDS Logistic, WPC number 28599 of 2021. Same matter, my lord. Identical issue.
Yesterday also your lordship has admitted one.
Given a date, yesterday's matter, we gave a date. What was the date, sir? Mr. Kurmi, yesterday we gave a date in the similar matter.
It was, my lord, in fact, yesterday I could not hear it properly, my lord.
What is all this?
25th of March.
Please, don't give us more and more work. You sit in a distant location and you don't even bother to find date in your own matter.
At that point of time, there was some problem in the audio, your lordship.
I beg apology, I could not about.
You also could not. Very good, sir. Excellent. And none of you can remember. What was item number at least you remember yesterday's?
I'll just give a slip.
That also you don't remember. Yesterday's item number you don't remember. Date you don't remember. Nothing you remember.
My item
Very good.
yesterday.
Today, if I dismiss this petition now, everybody will remember everything now.
No, my lord, just
Best way to make you all remember this petition.
My lord, yesterday's TSP. My lord, yesterday item 39.
Item?
Yesterday item 39, my lord, yesterday. TSP coal carrier.
on
My lord,
same-
weekly daily, my lord. Yesterday's weekly daily.
Along with reproduction civil.
WPC number 29186, my lord.
On 25th April, is it?
Yes, sir.
Or 25th April.
25th April.
I have already entered my appearance for opposite pendulum 2 and 3, my lord.
All right.
Obliged, my lord.
I may be pardoned, my lord. Item number 6, my lord. Senior advocate Ramakant Mahanti has instructed me to take time, my lord. Tomorrow it may be day or tomorrow.
What's the matter about madam?
My lord,
You just will pass it over. You just find out what the matter is.
my lord, that is, my lord, the petitioner, the opposite party.
One good idea would be to get the paper book. All right. We'll pass it over. You get the paper book.
Yes, my lord.
May, please, my item 13, my lord. This matter may be taken up along with the WPC number 31058, which is now urgent to 3rd January 23.
My lord,
List along with 31058 of 2022.
beg your pardon, my lord. My lord has already passed an order on that yesterday's case that he has to appear before the proper officer with the certified copies of.
But check that it is now urgent to 3rd January 2023. That's why I'm paying for the.
All right.
It's not disposed of. It is just urgent.
Not this.
Obligement.
Item 14,
None appears dismissed.
item 15,
None appears dismissed.
item 16,
Same order.
item 17,
May I please alert, sir? Mr. Mahanti is in accommodation. It may be taken.
We are not in accommodation, sir. We are not in accommodation. Sorry.
My lord, daughter's marriage because of that.
That's all right. So this is only in CMAPL. You have a paper book, sir?
No,
You have paper book.
no,
You have petition with you? Copy of the petition?
no.
We'll give it to you, sir. Please give it to him. We'll pass it over. You please argue, sir. Okay? Very good. Very good. Come.
item 18,
Pass it over, is it?
No, they said that the item number 10 is similar with item number 18.
80 or 18? I think it's 80. 80.
18 is different.
Call it 80.
item 18,
None appears dismissed.
item 19,
May I please, my lords?
What's the delay?
My lords, the assessment order was passed ex parte, my lords. The first appeal was filed and first appeal was allowed.
So 146 days delay, sir. We'll leave the question open, sir. There's a delay of 146 days in filing the present revision petition. The reasons set out in the application. This is MS case 99 of 2018. The reasons set out in this application are neither convincing nor reasonable. And accordingly, the court is not inclined to condone the delay. This application is dismissed. Consequently, the revision is dismissed. Nevertheless, the question is left open for decision in some other appropriate case. Question urged is left open.
item 20,
Item 20 and 21, no instruction.
No instructions dismissed.
item 22,
Item 22 and 23, I pray as not pressed.
Not pressed. Dismissed is not pressed.
item 24,
No, that next one also is a disposed of case. That application is dismissed. MC number so and so is dismissed. None appears dismissed. 23? No. You can call it 23, sir.
item 23,
None appears dismissed.
23 also not pressed, my lord.
All right. Dismissed is not pressed. All right.
item 24,
None appears dismissed.
Item 25,
None appears dismissed.
item 26,
Same order.
Ma'am, 26. This copy, kindly time allowed.
No, we're not adjourning. What's the matter? What? Come on, tell us. Tell us what the matter is, madam.
I have no idea.
It's all right. No grounds made out for review. Dismissed.
item 27,
27, 28.
All same order.
item 28,
Same order, sir.
item 29,
None appears dismissed.
item 30,
None appears dismissed.
item 31,
Same order.
item 32,
Same order.
item 33,
Restoration matter, I have dismissed the rate application. Madam. I have filed this application for restoration. Lease has been cancelled, my lord. I mean, the small scale industry has applied for lease. After inviting objections, the Tahsildar rejected and my lord, 7 to 11 dismissed, my lord. Other council was doing this, conducting, but on 14/3/16 he came to know.
Do you know how many days delay, sir? Are you aware?
About 5 years. About 5 years.
Just
My lord, 7 to 11.
5 days.
My lord, 7 to 11 dismissed. 7 to 11. 7th February 2011 dismissed.
Then what happened, sir?
And then 14/3/16 other council was doing this, my lord.
I see.
And 14/3/16 he came to know when the notice from the Tahsildar issued.
Very good.
And
very good, sir. Very good. You said there's a delay of 1, 2, 3, 4 days. That's a nice number. 1, 2, 3, 4. Very easy. 1934. Okay. 1934 days.
On this ground,
in filing this appeal for restoration, the reasons given in the application are neither convincing nor satisfactory. Consequently, the MC number so is dismissed. Accordingly, the CMAP is dismissed. All right.
All right.
I am sorry to Lordship. Item 14 matters a little late.
It's okay, sir. You'll have to wait. We are now in some other number now. All right. Sir, please, whatever number you're calling out, please call out that.
Item 34.
Yes.
May it please your lordship, my lord, I am through VC, my lord.
Yes.
My lord, this is an application for restoration of WPC number 1843 of 2009, my lords. My lord, the original writ application had been.
Sir, are you aware of how many days delay, sir?
My lord, actually, this was my lord, Mr. Patnaik was engaged.
No, we'll educate you, sir. Not a difficulty. It's only 1,034 days, sir. Only 1,034 days delay. It's a delay of 1,034 days in filing this application. 37. All right. Sorry. 37 days in filing this application. The reasons given are neither satisfactory nor convincing. MC number 146 is dismissed. Accordingly, the CMAP is dismissed.
Item 35.
None appears dismissed.
36.
None appears dismissed.
37.
Maybe it may be passed over for 2 or 3 chances.
Pass over.
38.
None appears dismissed.
39.
39.
My lord, questions of law are page 10, my lord.
What is the tax effect, sir?
Small dealer, my lord.
What is the tax effect?
66,000.
Leave the questions open. The tax amount being insignificant, the questions are left open for decision some other case. The revision petition is dismissed. Yes.
40.
My lord, appearing virtually, my lord.
Yes.
My lord, the question of law is at page 8, my lord.
What is the tax effect, sir?
It is, my lord, 13,10,000.
Defect is not removed, sir.
My lord, a copy is already served in the morning today.
We have a
Today
My lord, kindly see, I am manufacturer and supplier of coal tar, pitch and dehydrated coal tar. In the list C, under this matter under the OST Act, my lord, in the list C, there are items I am claiming that it will be called falling under coal and coke in all its form, chargeable to 4%. Assessing authority is classifying under bitumen, chargeable to 8%. First appellate authority is classifying under the residuary category, chargeable to 12%.
All right. Notice returnable 27th April. Right.
Obliged, my lord.
27.
notice.
Item 41.
This is the state appeal, my lord. The revision, sorry. The question of law is at page 17.
What's the tax effect here, sir?
Tax effect is 3,69,558. The question is answered by your my lords.
42.5. All right. Notice returnable 27th April.
42.
I am permitted to rectify the defect by next week.
No, what's last opportunity to remove the defects within a week, list that both 42 and 43.
43 also. Double.
44.
44 there are some defects I will
remove the defects within a week. Okay. Last option to remove the defects within a week, list thereafter.
45.
None of this dismissed.
46.
None of this dismissed.
47.
Yes, my lord. State's revision. The question of law is at page 9 of the revision petition.
Zinc dross.
Yes, my lord.
I think this we've already decided, sir. I think this has already been decided. Yeah. We'll do it some other time. Kindly verify, sir.
Yes, ma'am.
At the request of Council of the State, who needs time to verify whether the question is already decided in some other case. List on. April 3rd.
48.
Your lordship, there are defects in this matter to be removed.
Or last opportunity to remove defects within a week, list thereafter.
Highly obliged, your lordship.
49.
None appears dismissed.
50.
State revision, my lord. The question of law is at page 20. Question number A, that has been.
What is this defect not removed? Defect number 9. Last option to remove defects within a week is thereafter.
51.
Same here.
States appeal, my lord.
Same. Defect is not removed. You do it within a week.
My lord.
52.
Defects, sir. You remove the defect.
Is low, my lord. Tax amount is low.
In view of the insignificant tax amount, the question is left open. The petition is disposed. All right, sir. Thank you.
53.
53, my lords. I pray for a man to remove the defect, my lords. 53.
Impugn order not furnished, sir. For 7 years, 6 years, we have not removed filed the impugn order.
Also 1 week only.
Last opportunity to remove defects within a week less thereafter.
54.
54, my lord, state revision, similar question has been admitted, my lord, but the stack defect is 55,000.
All right. With the tax effect being insignificant, the question is left open for decision some other case. The petition is
55.
State revision, my lord, it is covered by my lord's that full bench decision. I have not brought that tall constructions case. Seven days issue, my lord.
Audit visit report. All right. In view of the decision, the full bench of this court and PAL construction.
Yes, sir.
Give the citation.
Daily.
The revision petition is dismissed. All right. Right, sir.
56.
My lord, I am on behalf of Mr. Satpathy. Today we have no instruction.
No instructions dismissed. All right.
My lord, liberty may be granted to
No,
file another
question.
if any cause of action shall be.
Not this matter, sir. Sorry. Yes.
57.
57, my lord, we will remove the defect within a week.
This is a review petition, sir. Come on, come on.
My lord,
What's the delay?
kindly pass over, my lord.
All right, pass on.
$58.
State revision, my lord. The question of law is at page.
What's the tax effect, sir?
82,006.
View of the insignificant tax effect. Question is left open for decision some other case. The petition is disposed.
59.
None appears dismissed.
60.
Same order.
61.
My lord, Mr. Kara is sick.
Kara is sick.
I see. All right.
10 days
Mr.
time.
Kara is stated to be unwell.
His
Matter,
other,
my lord.
his
What's
other
the
cases.
Oh, we'll do that.
At,
Sir. As and when they called out, you'd like to see. The delay is condoned. That dispense with that is allowed. The main matter, you say Mr. Kara is stated to be unwell. List on 20th April.
My lord, that is it's a 2J matter, my lord. The date
When is it coming up?
revision is a second week of week. I do not have the date, my lord. The
Dates. How many matters we've adjourned, sir?
6th February
List
2023.
on 6th February. All right. So if you people don't keep dates, you expect us to remember all these dates like this? Least assistance we require is these kind of.
All right, sincerely apologize, my lord.
62.
None appears dismissed.
63.
My lord, delay 13 days delay. My lord, if your losses may condone the delay. My lord, questions of law at page 25. Whether tax audit.
There's one defect. What is the defect?
File
D.
Forklifts. I'll
Yeah, so defect
rectify
you
the
removed within a
defect
week. All right, list thereafter. All right.
my lord. Okay.
64.
Delay. Tell us the delay.
64, my lord, Mr. Kara.
Yeah, 1 minute. This is not 2J.
My lord.
This is also 2J.
No.
86.
Oh, I see. All right. Mr. Kara is stated to be unwell. List on 2nd April.
65.
None appears dismissed.
60. 65. Paso Tushar Kanti Satpathy.
All right. 65 pass.
65 paso.
Yes, Mr.
May it please, my lord.
Yes, please.
This is similar to that litigation which is pending before your lordship, my lord, that relating to the RERA Act and ORERA Act.
Coming up tomorrow. When is that coming up? Tomorrow. Tomorrow. All
This may also be called along with that.
That's right. Tomorrow. List tomorrow. All right.
Obliged.
67.
My apologies, my lord. The petitioner filed this case in the nature of public interest litigation, my lord. The opposite part number 4
who is the villager, unauthorized occupation of the government land.
All right, your representation is served on them.
Yes, my lord, my lord.
Where is that? Proof of service, sir. Some postal receipt is there. All right, the petitioner's representation dated 1st September 2022 shall be examined by the collector.
My lord, collector.
Or Tahsildar.
Collector, my lord.
Collector Baleshwar, and after notice the petitioner as well as opposite party and after giving them a hearing, a reasoned order should be passed thereon not later than 3rd April.
My lord.
And a copy of the order shall be made available to the parties within a week thereafter. The court
Early case
clarifies it
already
is not
is-
expressed anywhere in the matter.
68.
Lord, I am sorry, on VC my video is not working. Representation is pending before OP number 2, my lord. My lord, I am on VC, my lord.
But the station and all, we are not interfering, sir.
No,
For
my
railway
lord.
station and all, we are not interfering.
No, for stoppage of the.
No. We're not
Railway.
interfering in these kind of matters, sir.
My lord,
This is a PIL asking for a stoppage between two railway stations in Nayagarh district.
I made
This is not a
representation-
matter in which the court would like to entertain a public interest litigation. These are all policy decisions of the railways,
Lord, I have
depending on the
made
exigencies.
representation.
No, the court therefore declines to interfere, dismissed. Sorry, sir. Yes.
69.
May I please, your lordships. The form of public interest litigation, your lordships, over the land of Kisam Gochar and Jalasaya, Mission Shakti home is being now constructed at the instance of the direction of the block development officer Kakarpur, your lordship.
Mission Shakti home.
My lord. Over the land of Kisam Gochar and Jalasaya. Your
What
lordship,
is your problem, sir? Mission Shakti is a state scheme. No?
My lord.
Why are you
But
opposing that?
it is being constructed. There are other government lands, your lordship. But land of Kisam Gochar and Jalasaya, my lord.
All right,
Over
the
the land.
petitioner's representation, bracket annexure 3, shall be examined by the project director.
My lord, collector, your lordship.
Let it go to the collector.
Collector provision after notice to the petitioners and giving them a hearing. A reasoned order shall be passed there or not later than 3rd April and be communicated to the parties within a week thereafter. The court clarifies it is not expressed.
70.
70 may be received. Is a application, my lordship, for on the PL matter, my lordship. The opposite party regarding removal of Lakshmi Puja Mandap situated in between Tampada Anganwadi Center to and
petitioner's representation.
I only pray that
shall be examined by the.
If a notice will be go to the opposite parties, my lordship, that they will appear, my lordship. They are disturbing and the.
Let the
two
defendants be disposed of fast. Let the defendants.
The students are not reading, my
Who has
lordship.
to deal? Tahsildar.
Sub-collector Cuttack.
Sub-collector Cuttack. Notice.
They are not obeying the
parties.
They are not obeying the
11 to 16. And after giving them a hearing, a reasoned order shall be passed there or not later than. Second, no.
My lordship, I only pray before I see that with my lordship permission, but they're not following the provisions of section 5 and 8 of the noise pollution, my lordship.
All right. 1st February.
Not even they are performing under the Gochar land, my lordship. The government land, they are creating noise and they are
order be made available to the parties within a week thereafter. The
Even
court
notice-
clarifies it is not expressed anywhere.
even notice will be notice.
Let the representation.
They are not following the rules, my lordship.
All right.
Even not the gazetted officer, not even not directed any kind of direction to the opposite parties, my lordship.
All right.
71.
My lord, 7 days time to rectify
All
the
right. Defects be cured within a week less thereafter.
72.
You had 72. There are some defects.
Yeah. Defects be removed in a week less thereafter. Same in 73, 74,
Yes.
75. 75 also. Right.
76.
None appears dismissed.
77.
None appears dismissed.
78.
Your Lordship, I'm in the vicinity. Your Lordship, may kindly look to order dated 14/9/2022, my lords. Passed in. It's a batch of 3 writ applications. Counter has not been filed yet.
All right. Counter be filed within 8 weeks, adjourned for the next date.
Interim order to continue, my lord.
List on 1st April. 3rd April.
Yes, I am appearing for opposite party number 7, my lord. So the last occasion, your lordship directed my friend appearing from other 2 connected matters to give copies. Till today, they have not served. Let them serve copies of the petition, my lords.
Whom are you for, sir?
I am appearing for Ferro Allies Scrap Nigam Limited. That's opposite party number 7 of the
copies of these petitions be served on counsel appearing for Ferro Scrap Nigam Limited.
My lord.
In all the petitions.
Interim
order passed in red petition
5100 of 2021.
5100 of 2021 will continue. Same order in all these matters.
79.
You would file an affidavit. What happened? That merger.
Yes, my lord, sir. That is.
More time is sought by the state to file an affidavit in terms of the order dated 19 September 2022. The said affidavit be positively filed on or before 16 January 2023. List on 20th March, 20 March.
Item 80.
Item 80, your lordship, in both the writ application, the grievance of the petitioner, they are objecting supply of water on rotation basis, your lordship, for rabi crop of junk irrigation at Nuapada, your lordship. In both the writ application, your lordship kindly take the WPC number 16617 of 2019 first. My lord, grounds, your lordship, my grounds are ground B, C, D, E. These are the important ground as your lordship. My lord, ground B, your lordship, the regulation has been passed without taking into consideration all the members, your lordship. And ground B.
So have you seen the counter affidavit?
My lord, I have gone through the counter affidavit, your lordship. This is on 27(1)B of the Pani Panchayat where the district level committee has the right to distribute water, my lord.
My lord,
only sole ground they have taken. But your lordship, kindly see my annexure, your lordship. Their decision is totally failed, your lordship. My lord, kindly see my annexure 14 of my WPC number 16617, your lordship. Every year for rabi crop, when water supply is giving, your lordship, every year there is drop. हर साल government को compensation देना पड़ रहा है हर साल. और जिस साल your lordship, the years in which they are giving water from 15 kilometers onwards, they violated the dam guideline, your lordship. They are keeping water more than 354 point. That is not, there is no permission to keep water from 350, your lordship, liter.
Yeah, if I heard you right, you said there is no permission to keep water.
Yes, my lord.
To keep water from 350.
350, your lordship.
What does that mean? Have you understood what this means? What is this sentence?
My
mean,
lord,
sir?
my ground.
Mr. Monty, when he says we are not having permission to keep water from 350, what does that mean?
A storage of 350.6 meter of water.
6 meter of water.
Who's keeping and who says to give permission for
The
that?
dam authority are keeping the violating without any permission.
Dam authority. Which dam, sir?
Yes.
Which dam?
Which dam?
My lord, Jong irrigation project.
So facts you have to say, sir. Suddenly you're just saying
There is no such disclosure in the writ petition. There is no government that this much of, but whatever it may be, what the action of the state government is supported by the Pani Panchayat decision that he is also admitting. And moreover, your lordship will, the project was noticed by order dated 6th January 2020. Specifically, your lordship has asked the OP number 5 to serve notice and file their counter. Whether the notice has been made sufficient.
I am appearing for opposite part number 5, your lordship.
Yes.
My lord, may kindly look at page 46. No doubt it is a water-starved district, my lord. There are 20 panchayats, and each year, because in order to maintain civil, my lord, this rotation of the water is made for each year in accordance with Rule 27, my lord, of the Pani Panchayat.
You filed an affidavit, sir?
I have not filed affidavit, my lord.
You better file, sir.
But your lordship may look at one page, order by page 46.
Affidavit is to be filed by them at least.
No, I will file an affidavit, but this is page 46. Your lordship directed the concerned authority, my lord, the secretary, to take a decision. And he called for everyone around. And at page 48, my lord, he has given a detailed order, relying on Rule 27(1)(b) of the Orissa Pani Panchayat rules. That rotation basis.
That is what is challenged here, I think.
That is impugned.
That is what he challenged. And I received the copy, my lord. I will file an affidavit.
All right. Counsel and Mr. Sargil and senior counsel appearing for opposite part number 5 states that he'll positively file an affidavit on or before 1st February 2023. Rejoined that to Feni be filed for the next date. List on 3rd April.
Lord, item 10 also come along with that.
List along with this on 3rd April. All right.
Item 81.
It's item 79, my lords. I was detained on the way while coming to the court, my lords.
You've given a date, no?
Yes.
What's the date?
Date.
Tell him, please. Loudly tell him.
20th March.
20th March.
20 March.
I'm obliged.
Item 81.
81 Miller, regender has already been filed and a copy has, regender has already been filed, Miller, and a copy has been served. But the opposite party number 7 is the vital, his counter is not there, Miller. He asking for time, Miller. Let them do. Opposite party 7 file the counter because.
Who's for opposite party number 7?
For OP number 7. I have filed an IA or grant of some time to file counter.
All right. IA 6347 of 2022. The application is allowed. For the reason stated, the application is allowed. Time for filing counter by OP number 7 is extended till 3rd April 2023. Rejoined that to be filed thereafter. Before the next date.
I'm appearing for OP number 5.
Yes.
Subject to your lordship's consent, we may also be given the liberty to file the counter.
Nobody will stop that, sir. We're very happy when counterfeits are filed. All right. Nobody will stop it.
Appearing for Vedanta.
List 19th April.
Obliged.
Item 82.
Yesterday we have filed the counter, man.
All right. Who's for the petitioner? None appears. Dismissed. Non-prosecution.
83.
Mr. Kara is sick.
All right.
Interim order to continue.
All right. Mr. Kara stated we unveil interim order to continue. 10th April.
Item 84.
This is
Item 84.
Ghana paste is.
there are
Two matters.
two matters.
86.
What about 85? 85 is over. No, 84 has two matters. So
85 is
Item
there.
85.
Ghana paste is.
86.
Same one.
With my permission, shall I pray? Shall one pray, my lord? Sir, item 70, my lord, one, just one.
Not in between like this, sir. We finish the list.
Wait. 86.
Yeah.
Item 87.
Same order.
88.
Same order.
89.
Difficult to catch your lordship, Lord. 11, 15, your lordship was 89.
What to do?
That's right, Lord. Lord, state is scoring like Brazil yesterday.
So we are also confused because one by one the cases.
Right.
All right.
Lord, out of these two matters,
yes,
in the item number 89, the second one is having real substance because the first one, Lord, I had challenged the format notice, but it has culminated in an order passed by the commissioner.
Which
the
you
second
challenged.
matter will be having
All right.
substance.
So first, we say due to subsequent developments, this petition has become infraction. The first one, it is disposed of as such. Second one, notice is gone already.
No, Lord, notice has not gone. It's a fresh matter.
Caveat petition. Whose caveat?
Lord, I have served a copy of it. No, yes, I have served.
All right. You said
No, I'm sorry, Lord. I'll serve a copy on OP number 5. I'm so sorry.
But defects are also there, sir. So you remove the defects.
I'll remove it, Lord.
Defects be removed within a week list thereafter. All right.
No, notice that.
No, notice है
90.
90 state has filed a counter. I'm supposed to file a rejoinder to this.
All right. Rejoinder to be filed with the next date. List on 10th April. All right.
91.
May I please?
Yes.
Lordship, may I kindly have a glance to page 16. That is a policy decision taken by the government of Odisha. The guidelines for sanction and disbursement of capital investment subsidy under the agricultural policy 2013. So Lordship, may have a glance to serial number 4. Commercial calf rearing center. This is a program of the government of Odisha. And I will take your Lordship to page 25. This is a policy decision of the government of Odisha. Agricultural Policy 2013 regarding commercial calf rearing center. At page 25, it has been specifically mentioned in paragraph 3. The district nodal officer shall keep the certificate signed by the collector and chairman of the scrutiny subcommittee along with all the relevant documents and issue the advice request to the Deputy Director Agriculture for issue of check through his online field directly, and entrepreneur in self-finance cases and concerned financing bank to the bank finances cases. That means after the collector, the chairman of the subcommittee is satisfied and give a certificate that someone has established a calf rearing center, then upon his certificate, the Deputy Director Agriculture shall issue a check of subsidy. As per this policy, under Annexure 2, I make an application. Under Annexure 3, at page 37, they issued a letter, go ahead with the project. Accordingly, we proceeded and established the project. And at page 48, under Annexure 7, the collector issued the certificate as the project has been completed. Your Lordship, I am taking your Lordship to page 48.
Yes.
Let me place the whole thing because as per fixed schedule, the district level scrutiny subcommittee meeting for the year 17-18 was held under the chairmanship of the collector and district magistrate Sambalpur on 20th of February 2018 at 5 p.m. The member of the committee present is reflected as Annexure 1. The Chief District Veterinary Officer Sambalpur cum convener presented both the proposals received by him. Nodal Officer ARD Department so and so. Agenda number 1.
No, that's not convenient.
I am concerned with agenda number 2.
So read that.
Regarding the project under commercial calf rearing scheme of Srimati Subarna Mishra, so and so, Manesur, the CDBO Sambalpur cum convener is informed the issue that the evaluation of the said scheme has been completed both by financing bank and the department as detailed below. The joint verification of the project by CDBO, DDA, AAE was conducted on so and so. And the project has been mentioned, the cost of the project is 30 lakhs. And next paragraph, the scrutiny subcommittee approved evaluation report furnished by CDBO and sanctioned capital investment subsidy amounting to rupees 50 lakhs. That is 50% against the investment of 30 lakhs only as evaluation amount by the bank, and the department is more than the project cost as per the approved DPR. The committee decided to issue subsidy approval certificate in favor of Srimati Subarna Mishra and proposal of Apical Bhubaneswar to release the subsidy. This is the certificate issued. The person present, the next page is the person present, including the collector and all other committee members were present. And under Annexure 8, they issued a certificate also. They issued a certificate, subsidy approval certificate, page 50 certified that the total capital investment cost of commercial calf rearing center under animal resource development established by Subarna Mishra, so and so, after detailed evaluation of Sambalpur.
But they are referring to 18th August 2015 letter.
If there is a policy decision is taken by the government, a DO letter will not supersede the policy decision of the government.
What is your answer? What is your answer to that 18th August letter?
Page 65 of the brief, Your Lordship.
Right. And
this is a DO letter.
Yes.
It will not supersede the executive.
No, you have to say something instead of just saying supersede. Have you complied with these requirements or not?
Then here, as per the statutory requirement, the deputy director is project cost is less than 1 crore. There, the deputy director is authorized to issue the subsidy checks. That is the page 25 I have brought to Your Lordship's notice. Now, and again, I will take Your Lordship to page 25 of the brief.
So first answer the question. You're not answering the question. Why are you running away from it? Annexure A5. Come to that Annexure A5.
My Lord,
page 66.
Page 65. Yes. This is with reference to your suggestion, the above cited letters on the caption subject, I am to inform you that the order to ensure proper dispersal of the utilization of the earmarked subsidy amount applicable is entitled the owners of released to the eligible beneficiary through banking channel.
Sorry. They say in the counter affidavit, just come to the counter affidavit.
Counter affidavit. Yes, my lord, in the counter affidavit.
Para 4.
Yes, in the para 4, that in reply to the affirmative it is humbly submitted at the petition Subarna Mishra of Loknath Mishra, village so district Sambalpur had applied on so for establishment of a commercial calf rearing center under the commercial agricultural enterprises under State Agriculture Policy 13. The petition has never been denied of getting the benefit of capital investment subsidy CIS as per the State Agricultural Policy 2013 as amended till date. Rather, she has been requested to comply the observation as indicated herein below made by the competent authority, that is the Managing Director of Apical, for release of CIS as per the modified guidelines dated so and so. The copy of the said letter dated so and so is annexed herewith as annexed. Then I will take your lordship.
No, below
page
that there is something written, sir.
My lord, page 25, I will take your lordship.
No, below this, you're stop reading somewhere.
The requirement is the copy of this letter so and so dated is annexed herewith as annexed A/5 for kind perusal of the Honorable Court. The go-ahead has been issued for calf rearing project, but you have set up a dairy farm.
Read on, read on.
You have neither purchased any female calf aging between 4-5 months, nor made any agreement with the female calf supplier for minimum 10 years. No purchase receipt has been submitted to this effect. As it is a calf rearing project, there is no need to purchase milk machine. Construction of cow shed is also not required for the project. Photograph of the unit calves need to be submitted. Veterinary health certificate along with the insurance policy of female calves need to be submitted duly countersigned by CDVO of the bank. This is required in respect of a project which is more than 1 crore. That has been mentioned at paragraph 20, page 25 of the brief, where it is provided where the project cost is more than 1 crore, then the MD applicable is the appropriate authority and he for these requirements. But in respect of the project which is less than 1 crore, that has been mentioned in page 25, where it is required that the collector will hold an inspection. If the collector will satisfy about the fulfillment of the requirement, then the collector will issue a certificate, and as per the certificate of the collector, the subsidy will be released. This is not required. They are referring to A/5. That is in respect of a project whose cost is more than 1 crore. That is mentioned in the policy itself at page 25.
Right. All right. Yes, please.
There's the change that has happened, which my lords will see at annexure A5, that's with regard to the modality. So in effect, he has not been denied that he'll not get the capital subsidy. It's just that the queries which have been put by the MD Apicol.
How is it applicable? That's for a project of more than 1 crore.
Because
that's not for this project at all.
Because that comes from that from the modification that is dated 18th of August 2015. Please read it. With reference to your suggestions in the above cited letters on the captioned subject, I am to inform you that in order to ensure proper disbursal and utilization of the earmarked subsidy amount, Apicol is entrusted the onus of release of subsidy to the eligible beneficiaries through banking channel. The Deputy Director of Agriculture will not issue the check directly as mentioned in the guidelines. Rather, he'll send the request for release of CIS to MD Apicol after getting the release advice from the sectoral nodal officers. After getting the request for release of CIS, advice will be given in their online field to the concerned bank for depositing the required subsidy, including the refundable.
Where are you getting all what you've said in the affidavit from this letter? You have annexed some other affidavit. Whatever is said in the paragraph, that you have to have no need for cow shed, no need for this and that. That's not coming from this letter at all.
My lords, annexure 12 of the writ petition, my lords. That is the letter that has been addressed to the petitioner, to the Deputy Director of Agriculture by the MD Apicol.
But how is this applicable to this project? It's for 1 crore and above.
Since my lords post this 2015 letter,
that nothing. In fact, 2015 letter does not talk of 1 crore project or less than 1 crore at all.
No, my lords. It doesn't talk about 1 crore project. It just says that the disbursement.
How is that relevant, sir? He's not worried about who's the disbursal authority. He says my project is less than 1 crore.
Please,
these conditionalities apply only to projects 1 crore and above. Where's the answer to that? You're referring to some letter which does not answer that.
No, let me take you to annexure 12.
All right.
Please.
All these 4-5 conditionalities in annexure 5, annexure 12.
Yes,
You're referring to annexure 12.
Yes, annexure 12. May I read?
No need to read, sir, because all this is said which you just now read.
Yes,
His answer to this is these 5 conditionalities do not apply to projects less than 1 crore. That's his point. What is your answer to that?
The short answer is that at the MD APICOL level, there is a scrutiny of the CIS proposal. So thereafter, if that letter starts with inviting a reference to the above cited letter on the caption subject, it is to inform you that during scrutiny of the CIS proposal.
So this is what is being challenged here.
Yes, Milord.
You're reading something that has been challenged. No, he's saying these defects cannot be pointed out because my project is less than 1 crore.
But Milord, since the nodal agency is APICOL, so the nodal agency has to be satisfied that the CIS proposal
no difficulty, but if that conditionalities don't apply, then the nodal agency's satisfaction is erroneous.
Then the petitioner here could have just written a letter to the...
So it will get resolved. Should we record your statement that he now writes to APICOL, it will get resolved?
And still date, after this annexure 12, there has been no correspondence by the petitioner.
Sir, he's here in this court.
Yes.
He's telling you this does not apply to him.
Yes.
You want to go him to run around in circles, or you want to answer him in this court?
A counter affidavit surely doesn't directly answer this particular question. My suggestion would be let him represent before APICOL.
No question of running around like this in circles, sir. Answer his point right now and here. He has come to this court. He's given you a specific grievance. He says these conditionalities do not. In fact, he has annexed this.
Yes, Milord.
And he has said that this does not apply to him.
Let me take instructions on this specific query, Milords.
This is the only query, sir.
Yes.
There are three different kinds of projects. Come to page 25.
Yes, sir.
Projects within 1 crore, projects above 1 crore, projects about 20 crores. And his is within 1 crore.
Yes. Well, this was in 2013. Thereafter, Milords, we are relying on the 2015 communication.
So that communication of 2015, please tell us. That communication says that his project is to be evaluated.
That communication only says that the MD.
So you are repeating.
Yes, ma'am.
You are not answering our question. This is a very. You think it is a good way of arguing? No, you be satisfied with it. We are not satisfied. When the judge asks a question, we expect an answer. You keep answering something else. You're not answering the question.
Fairly, Milords, our counter affidavit doesn't answer that question.
So what do you want to do?
Let him go before the nodal authority, not before the APICOL, and they will his request for.
So they've already processed. I think you missed out the whole point in the case. They've already given a subsidy. Come to page 50. All this is already over.
Yes, they had in fact given a certificate as well.
I've seen. What more does he's just waiting for a subsidy with all your certificates? You're still not giving him the subsidy. The grievance of the petitioner is that despite a letter issued by the Deputy Director of Agriculture on 26 March 2018 to the Managing Director, APICOL, Bhubaneswar, confirming that the document submitted by the petitioner for release of the CIS claim in her favor to be open quotation, verified and found correct, unquote. Till date, she has not received the CIS amount. Full stop. It is pointed out that the so-called single quotes defects, unquote, sorry, discrepancies, unquote, pointed out in the letter dated 28 April 2018 of APICOL to the Deputy Director Agriculture, bracket Annexure 12, do not apply to the case of the petitioner, since hers is a project of less than rupees 1 crore, to which the above the said conditionalities do not apply. Paragraph. The counter affidavit filed by the opposite parties do not address this specific issue. Full stop. A reference is made to a letter dated 18th August 2015 from the Directorate of Agriculture and Food Production to the Managing Director APCOL, which does not answer the query posed in the present petition, namely whether the discrepancies pointed out vis-a-vis the petitioner's application, in fact, apply to her at all or not. Paragraph. Mr. Monty, learned additional standing counsel, that a further affidavit will be filed within 4 weeks, specifically addressing the issue pointed out here and before. List on 24th January.
Item 92.
92, my lord, it's time to finally written note, or as your lordship directed earlier, my lord, I've not yet prepared notes. 1 week time may be granted so that I drafted, but it's not finally because of the concerned authority is not in the office. So I need 1 week time to finalize the.
Well, it's Mr. Ganesh leading us is appearing through VC.
All right. Yes, Mr. Ganesh. You're on. You're not audible, Mr. Ganesh.
I can hear your lordship.
Now you're audible. Yes.
Okay, very well. Yeah. Lord, I appear on behalf of the respondent SSC. I only say one thing. Lord, the finding which has been given by the appellate tribunal in this case speaks for itself. It's a pure finding of fact, which is fully justified by a detailed discussion running into almost 3.5 pages in the appellate tribunal's order. And the summary of the finding is that the requisite approval under section 153D of the Income Tax Act of the Commissioner has been given without any application of mind at all. The requisite documents have not been placed before him, and 7 years papers were supposed to have been considered and dealt with by him in the span of just 1 day, and therefore it is impossible for him to have the requisite time to deal with it. So it's a simple question of fact. And on this, Lords, the Supreme Court has said that when the tribunal has given a finding of fact, the only ground on which it can be assailed is on the ground of perversity. And the issue of perversity has to be raised in the appeal, number 1. And number 2, the issue of perversity has also to be made good by the person who seeks to challenge the finding of the tribunal. Here, there is not one word of perversity in the appeal filed by the department, nor is there.
Only thing, Mr. Ganesh, is that he wants some more time for filing a written note of arguments.
Lords, if it is only a
for the department.
Lords, the hearing can be completed today. Otherwise,
Lords, Lord, I may not give the justice. I'm requesting my senior team.
Seeing on the screen that he's got even more nervous now.
But Lords, let me point out to my lords the injustice which is being done to me. The tribunal held in my favor in January. The matter came up before my lords in this appeal in August, on 4th of August. That is 4 months ago. Now, lords, they applied for a stay of the order of the tribunal, which my lords did not grant. And on the contrary, my lord specifically said that any refund which is granted to me, because there is a refund payable to me pursuant to the appellate tribunal's order, will be subject to the result of the appeal. Now, that was 4 months ago. In the last 4 months, despite repeated requests, they have not released the amount of refund. And today, my learned friend asked for time. And lords, on what ground? He says, I need a note of arguments. But we only have to consider whether the finding of the tribunal is a finding of fact or not.
We'll just give him one last chance and we'll proceed with the final hearing this time. All right. Counsel for the department seeks one last chance to file a written note of arguments along with case law.
The shortest possible date, my lord.
All right.
Shortest possible date.
All right.
Yeah. Lords, I moved an IA 118 in which I made a request that there should be a direction to them to release the refund subject to the result of this appeal. It's a very
We'll just issue notice on that. Yeah, IA 118 notice, he accepts notice. You say list on 22nd February for final hearing.
Could it be in December itself, Lords? I'll be very
No. There's absolutely.
It really will not take time.
Closer to vacations, you know how it is, Mr. Ganesh.
No, may I only say one thing? I'll take only 30 seconds of my Lord's time. Lords, I will not take more than. I will not. My learned friend should permit me to address the court. Lords, Lords, I will not take more than 5 minutes, Lords. And just two judgments which I will place.
I know. Have a clear day. Otherwise, again, it will get adjourned. December is just not possible.
Can we have a date this side of the vacation?
No, that's simply not possible. You know how it is closer to the vacation, the board is chock-a-block.
Then some date in January, my lords.
No, 22nd February, because that is a clear date. I've got the list of matters. I know which one will reach and be taken.
January is not possible to accommodate.
No.
May I submit, my lord?
My lords consider passing an order on my IA. Let them at least release it subject to the result of the appeal.
We'll issue notice on that. Let him.
Actually, that order is already there. So
only then may I make one other request? I'm sorry.
All right.
My IA be listed this side of the vacation.
No, it's all right. It will all come. No, let it all come up.
That won't take much time, Lords.
No, I know. And based on order, irrespective of the written arguments being filed, the matter will proceed on the next date. All right.
May I submit, my lords? I am appearing in one of the appeals. That is ITA 44.
All right.
My lords, here, by virtue of the proviso to section 260A of the Income Tax Act, Lordship may have the perusal of that proviso.
Right.
Lordship is also empowered to any additional question.
All right.
Lordship my prayer is 2 additional questions may be framed. Lordship
have you filed an IA for that? You file an application, sir. You file an application. We'll consider that.
260A 4 ballots.
I know, but you file an application. Yes. Then they'll have a chance to respond properly.
Yes.
All right. You're along with.
Yes, 45.
I see.
45.
All right. Okay.
I'm grateful to my lords. I'm very grateful.
No. Always.
Pass over item number 6.
Lordship, in the meantime, I may be permitted to mention one matter, Your Lordship.
Yes.
Kindly, I was on item 77.
Yes.
But I was throughout present, Your Lordship. But during that time, this audio device could not work. Therefore, Your Lordship has been pleased to dismiss that matter for non-appearance.
Which matter, sir?
Item 77, Your Lordship.
All right, tell us what it is about. Tell us.
It is about the recruitment of the presiding officers in the DRTs, Your Lordship. So in that matter, Your Lordship, I had applied for a post, but in the meantime, the central government, without going into the judgment passed by the Honorable Supreme Court that to allow the advocates who are having 15-year experience to apply for that post, they have made selection without calling for the other advocates. They have changed the rule for Your Lordship, has issued a notice and they have not yet filed the counter, Your Lordship. And today also they have probably a copy has not been solved. I don't know whether they have filed a counter.
No, I don't think they have filed. Mr. Party?
Yes.
Today we are filing counter affidavit.
All right. Counter affidavit have been filed today, be placed on record. You'll have to email it to him, sir.
Yes, sure.
It be sent by email to the petitioner today itself.
No, I will collect.
I'm sending
whatever, sir. All right. Rejoinder be filed before the next date. List on 3rd April. Right.
Your Lordship, in the meantime, matter will be infructuous, madam. Your Lordship, because why I say this? Because already 2 years has lapsed. Your Lordship, kindly consider that the advocates are eligible. I may say I will not file a rejoinder. Kindly consider their counter affidavit and call this matter next week, Your Lordship. It will be disposed of.
No, not
this matter is lingering since long and the matter will be infructuous. Although there will be no use.
All right.
April, Your Lordship, yes, kindly say in the month of January, Your Lordship. Because it will be far delay. I will not file a rejoinder. Kindly consider their application and pass any order. Please don't keep it.
27 January. All right. 27.
I am obliged, Your Lordship.
We modified the interim order.
Sorry, sir. 1 minute. This is a Friday. Sorry.
To the effect that
31st January.
by a simultaneous disbursement certificate issued.
Pass over item number 6.
In this case, my lord, the writ application has been filed by the respondent, my lord. and that during the probation period, his service was terminated because due to non-performance of the he was advised to do better performance, my lord. And your lordship, my lord, in the writ application, the honorable single court, my lord, the single judge, my lord, has pleased to make observation and direction mainly on the ground that the order of termination of the respondent who was a probationer was stigmatic and punitive, my lord. Hence, my lord, his service was terminated, my lord.
Correct.
My lord, kindly see the, my lord, para 8, my lord.
Yes.
After the punitive stigmatic, my lord, which is proved by the respondent himself, my lord, since he has got appointment, my lord, in a nationalized bank after order of termination, and thereafter, my lord, he has got OS, my lord, and he was now.
Who's appearing for the other side? Who's appearing? Has notice been served on him?
Yes, my lord.
One Vidyadhar Mansingh was appearing earlier.
It may be taken upon some other day, my lord.
You see, one Mr. Vidyadhar Mansingh, advocate, was earlier appearing for the respondent. Stop today, despite a pass, none appears on his behalf. Stop. Interim order to continue in the interest of justice list on 10th April.
10th April.
Yes.
Item 8. Pass over item 8.
None appears despite a pass. Dismissed.
Pass over item 17.
I beg your lordship's pardon, item 14 mailers. Item 14, your lordship is dismissed for default.
Tell us what it is.
On 8/1/2015 mailer. Dismissed for default.
1 minute, sir. Tell us what the matter is about. Tell us what the matter is about.
Matters the regulation of the petitioner, that was claim of the petitioner was turned down by the London Tribunal, and against that the petition has been filed by us. So that was the default.
No. Tell us what the main matter is, sir.
Main matter is for regulation of the case services of the
petitioner. So show us from the impugned judgment what is wrong with it.
The petitioner was appointed by us in April 1992 under the opposite part number 4 mailers, and has been continuing also till that he has been continuing, and he approached the London Tribunal for regulation of his services, and that was turned down by the London Tribunal mailers. But the juniors to the petitioner, they have already been regularized. I have also got the documents.
Engaged.
Mailers.
He was appointed in 3/4/92 as a field man demonstrator.
3/4/92, and still that he is continuing mailers. Till that continues to his service.
Anyone appearing for the state?
Yes.
Are you aware of this case? You have a paper book.
We don't have the main file, my lords. I'll have to retrieve it and come back.
All right. You just see CMAPL. You say for the reason stated there, the order dated 28 January 2015 is recalled. First, that control the delay in filing the CMAPL. Then, for the reason stated that the order is recalled, the CMAPL is allowed, and petition civil 14091 of 2010 is restored to file. In the main writ petition, you say a copy of the writ petition be served on counsel for the state within 3 days to make instructions in the matter. Stop. It is claimed by the petitioner that he is still continuing in service as. What is your present designation, sir?
It's a fieldman demonstrator mailers.
Fieldman demonstrator. List on 10th April. This is the main. Okay.
Pass over item number 17.
Fieldman demonstrator, now called mailers, soil conservation demonstrator. Soil conservation demonstrator. Designation change. Public.
Yes, sir. Tell us.
It's a matter of dismissal of a public interest litigation about discretionary quota for land allotment. And at that time, because of some difficulties, the counsel from Delhi couldn't present in the court. So because of that, non-appearance dismissed. On that request, we have filed this. And I am not much acquainted with the facts, Mr. Mahathir, in accommodation. And
all this you can go to the Lokayukt, sir. These are matters for the Lokayukt. So you say that same APL, for the reason stated therein, the order is recalled and writ petition 905/14 is restored to file. And then in that writ petition, you say the prayers, having perused the prayers in the present petition, it appears that these are matters which can be agitated before the Lokayukta in accordance with law. Accordingly, the court declines to interfere in the present petition with liberty to the petitioners to approach the Lokayukta in accordance with law. The petition is disposed of.
published.
Pass over item number 37.
May I please your lordship's madam. This is restoration of the case filed by the petitioner who applied for the post of notary
So
in the
37 is STREV 1 of 2016. Sales tax revision. Item 37 is the sales tax revision, madam. Yes. Item 37 you said despite a pass over none appears dismissed.
Pass over item number 57.
My lord, I am.
Pardon to mention, Lordship, item 46, Lordship. Lordship, in item 46, some defects are pointed out by SR, Lordship. Kindly given 1 week's time to remove. Item 46, Lordship.
46, you say last opportunity to remove defects within a week. What's the limitation? Any idea? I think file is not here. All right.
My lord,
46.
46, Lordship.
Item 46. Item 46. All right. List that up.
Pass over item number 57.
It was 35.
I am appearing. Sir, I am appearing on behalf of the
I asked for passover in the matter, my lord, 37 by mistake.
Oh.
That is for 35, my lord.
All right. Tell us 35. What is it?
This is with regard to restoration of the case filed by the petitioner who applied for the post of notary in the district of Moirbhanj at Udola in the year 2005 when 4 vacancies were there and he was the only applicant.
Huge delay
And
in
all
filing.
the applicants made
There's a huge delay in filing this CMAPL. Because it was dismissed, they dismissed on 11/12/2013. And you have filed this on 22nd July
it is
2016.
due to the mistake of the
No, what? Can't be more than 3 years, madam.
mistake and oversight, my lord. I have mentioned the cause that the advocate for the petitioner go on filing memos to list the matter. When the matter could not be listed and the advocate telephoned, then I verified, my lord, personally. Then I came to know that due to some order, peremptory order passed by this honorable court, and I have annexure 1, I have filed that monthly list maintained in the office of the advocate. There, that matter does not find place. That is due to the mistake of the advocate. That matter could not be, I could not take any action. That monthly list also I have filed, my lord. That several cases are there that annexure your lordship may see. Generally, we advocates used to maintain that there that case does not find place. So that 2005 only 4 vacancies were there, and he was the only candidate applied for the post. But he was not in appointment. Then subsequently also 2012 again he applied for the same post. Then he was not called for the interview even. I have mentioned all the report of the learned districts, the Bar Association secretary, everything.
What is the prayer? Kindly read your prayer in the main writ petition.
Yes, my lord. Upon by the rejection of appointment of the petitioner as a notary at Udola will not be declared as
illegible.
Illegal, that is typographical mistake.
All we have to excuse everything.
It happens due to this computer. Sometimes it happens. If it is understood by your lordships, that
No, we have to understand everything. So
but
I think
yes, extremely. I am sorry for this. My mistake, man. Illegal by quashing annexure 15 by directing the opposite party number 1 and 2 to appoint the petitioner as notary as Udula within the stipulated time. What has happened earlier also, he applied before your lordship, he approached this honorable court, then order was passed. Thereafter even they did not give appointment. I have mentioned everything there is.
Everyone who applies won't be given one rejection order. These are all applications for notary public appointment.
Yes, there is no other alternative than because the Notary Act speaks up.
What?
That yes, I have fulfilled all the paraphernalia that I qualify for that. Notary Act speaks up, my lord, that he has to complete that 10 years of experience. 96 he enrolled as an advocate and he applied in the year 2005.
Every lawyer completes 10 years. If he starts becoming a notary, then we'll have some lakhs of notaries.
That is only fact remains in the year 2005 for 4 vacancies. Only applicant, he was the only applicant. He was not, his case was not
We don't
considered.
even know now what the positions. 22. We are in 2022 now.
As your lordship knows, due to in spite of my best efforts, the matter could not be listed. Then thereafter, I have filed several memos.
Many more notaries have been appointed since then.
It could not be.
No, there is a fixed number of licenses they issue for notaries. Not everybody gets it.
No, my lord, I have mentioned that in the district of Mayurbhanj, 35 notaries are to be appointed. And for Udula, 6 posts are there. And 2 are working. Then 4 were lying vacant. And for 4 posts, only 1 person, this petitioner applied. And he qualifies and he has deposited the fees. Then there is no alternative than to only appoint him. But that has not been done. The reason best known to the that only with the law department, most probably it could not be done.
All right. Just CMAPL, you say issue notice. Returnable on 17th April. All right. Yes.
Pass over item number 57.
Sir, I am appearing on behalf of the workman, the petitioner in the review petition. I may be permitted to make my submission through virtual mode.
Yes. What's the delay?
So delay 49 days, ma'am. Yes, sir.
All right.
48 days.
Yes, tell us, sir.
Sir, the award under the challenge before the court is the writ application by the Allahabad Bank, that petitioner bank. That was an expert award before the Central Industrial Tribunal, Bhubaneswar. And during the expert hearing, the workman has produced all the relevant documents, and that was also, I have filed also the order sheets of the learned tribunal, that is at page number 42. Therein I have mentioned the workman has filed his evidence affidavit and the photostat copies of the documents as per the list of the expert evidence. But the there is a error apparent on the order passed by the division bench, and that they have, in paragraph 16 of the judgment, they have taken note that without any material before the tribunal has passed the award. So when all the matters are placed before the tribunal and without calling for the LCR by the annual court, the ex parte award was set aside, or even the matter was not remanded back to the learned tribunal for its, because the management plea was that they were not given the opportunity of hearing before the tribunal. So without remanding the matter, at least the order was passed and the workman was deprived of his right to produce all the documents. Even the management has also not produced the documents and the order sheets before the during the hearing of the writ application. And the workman could not able to get the opportunity also to produce the documents before the hearing of the writ application. So instead of remanding the matter, at least to give an opportunity of hearing to both the parties, the impugned order was passed.
These are not grounds for review, sir.
Sir, this is the order was passed that there is no material before the tribunal to pass such an award. So when the material is on record, that is, I have annexed, I will have a glance to page 42. That is the order sheet of the learned industrial tribunal, wherein order sheet dated 7th October 2013. Kindly have a glance to page 42, sir. Case taken up, none is present for the first party management. The second party workman is present in person and files of his sworn affidavit along with 11 photostat copies of the documents as per the list in the ex parte evidence. So when admittedly, sir, all the documents are placed by the workman. So the without calling for those documents at least, or without remanding the matter to the tribunal, the court has
You have to unmute yourself, sir. Kindly speak.
Sir.
Proceed. Kindly proceed, sir.
Sir, all the materials on that is which will prove the employer and employee relationship and the period of continuous service of the workman. Those are submitted by the workman, but in the impugned order, it was stated that there is no matter.
Sir, you're certainly aware you're arguing a review petition, correct?
Sir.
Are you aware you're arguing a review petition, sir?
Sir.
You are aware of the parameters of review?
Sir, to my knowledge that this is an error apparent on record because the relevant materials were not, which was not on the record, because the ex parte award of the tribunal is under challenge. But instead of at least remanding back the matter to the tribunal, or instead of calling for the LCR, this impugned order was passed, which is apparent on the which is error apparent on the face of the record, sir.
No.
So, and even the paragraph 16, man, kindly have a glance to my submission in page 10. Page 10, sir, ground number D.
Yes.
So therein I have specifically, sir, mentioned that the award is under challenge was ex parte award, and they admitted this shown in affidavit of the workman and the order sheet of the tribunal, which are document evidence by the workman in the tribunal, were not filed by the management. And without taking into consideration all those documents, and without giving an opportunity of hearing to the petitioner workman, the impugned order was passed, which is error apparent on the face of the record, sir, which needs a kind interference of your honor.
All right. No ground is made out for review. The review petition is dismissed. The delay is controlled. Right.
Pass over item number 65.
Lord, similar matter yesterday, Your Lordship adjourned to 6-3 on the ground of substitution, Lord. Property expired and very recently, Lord, and Your Lordship, it is an entity test earlier that it is an bad, Lord, earlier.
At the request of counsel, the petition list on 6th March.
6/3/2022, along with 86 of 2018.
STRV 86 of 2018. All right.
Copy to be solved.
I'll serve.
Lordship, pardon to mention, Lordship, item 59 and 60. Lordship, kindly taken up next week, Lordship. This brief is transferred to us yesterday, Lordship.
All right. 59 and 60 at the request of counsel for the. What's the delay? There's a delay, right? 185. 17 days. All right. Counsel, at the request of counsel, the petitioner. Last chance is granted for removing defects pointed out within a week. Just page 59, item 59 is it. List thereafter. In item 75, you say at the request of counsel of the petitioner, who states that he has just been engaged. List on 11th April.
Lord, I may pardon to mention, I'm from virtual Lord, item 84 to 88. Lord, I have missed it is, I think, Lord, a lot of dismissed by default.
Tell us.
Lord, item 84, this is two matters are there. It is covered by judgment, Lord, TCS matter, and your Lordship also passed a similar order. But I'm handing over the order to your Lordship. 84, two items there. That is covered matters to TCS matter. And it has been allowed by the Honorable Court. And your Lordship also following that judgment also passed order that I'm providing. Similar order may be passed.
Dates will change, no?
Yes, my Lord. That date will be changed. Demand notice will be, date will be changed. Demand notice is 7/3/2018.
In both matters?
Yes, my Lord. Next item, 85. That is regarding audit objection. And your Lordship's directing the Secretary to decide, because here I have not challenged the subsequent revised excise duty. It is a 2018 matter. So revised demand is duty is 2021. So Lordship, in this matter, direct the Secretary to decide.
All right, same order.
That order I have given. But that same order will be on 87.
87, same orders. All right.
And my Lord, 86, there is a demand notice. My Lord, I will challenge. It is issued by the collector. So I'll file appeal before the commissioner.
All right. You say in 86, you say counsel the petitioner seeks leave to withdraw the present petition with liberty to file an appeal before the commissioner.
Yes, Lord.
Excise commission accordance with law, disposed of is withdrawn with liberty.
Item 88 not pressed, Lord. Item 88 not pressed.
88 dismissed is not pressed. All right.
Lordship, I am appearing in the item number 84 as opposite party. Lordship.
All right.
Obliged.
Yeah, weekly.
Weekly list, item number 1.
May I please?
Yes, please.
It's the order dated 31st January 12th January 2007, passed by Somoto revision. Annexure 3, page 18.
Yes.
The order under challenge in this appeal. The grounds of challenge is confined to 3 only. Whether surrender of.
How come this? It's straight away you've come here. Comes order. It doesn't go to a tribunal or anything, is it?
No, it's against the Somoto revisional order.
So there's no further thing to the.
No. Against the appeal, they have revised the appellate order, Somoto.
I see. All right.
So the question is whether surrender of a exim script license amounts to sale so as to attract the provisions of Sales Tax Act.
That's covered now.
Yes, that is covered by the recent decision of this Honorable Supreme Court. That is 2016-10 SCC 595.
Let's see that.
Paragraph 38.
Covered in your favor or against you?
It's in my favor.
All right.
And the second submission with regard to the limitation to pass the order, that is also answered in my favor by a coordinate bench of this Honorable Court.
No, first let's see this on merits. If it's not a sale, then that's the end of the matter.
It's exactly on the same footing.
No. So what paragraph?
Paragraph 38. My lords may come to paragraph 1 first. What is the question before the Honorable Supreme Court? May I permitted to place my lord?
Yes, please.
The seminal question that emerges in this appeal is whether State Bank of India and its branches, which are registered dealers under Bengal Finance Sales Tax Act 1941, would be liable to levy purchase tax under section 56A of the Act for accepting the exim scripts export-import license on payment of premium of 20% of the face value of the scripts in compliance with the direction contained in the letter of Reserve Bank of India dated 18/3/1992. The authorities of the revenue as well as the taxation tribunal had held against SBI, but the division bench of the Honorable High Court in a writ petition has dislodged the said conclusion, holding inter alia that the purchase of exim scheme by the bank did not attract the provisions of section 463 of the Act and resultantly quashed the orders of the fora below and issued consequential directions. My lords, the finding is at paragraph 38.
Thus analyzed.
Yes, thus analyzed, the replacement license or exim scripts would therefore be goods, and when they are transferred by the owner to a third person for consideration, they would attract sales tax. However, the position would be different when replacement license or exim scripts are returned to the grantor or the sovereign authority for cancellation or extinction. In this process, as and when the goods are presented, the replacement license or exim script is cancelled and ceases to be a marketable instrument. It becomes a scrap of paper without any intent market value. SBI, when it took the said instruments as an agent of RBI, did not or purchase any goods. It was merely acting as per the directions of RBI as its agent and as a participant in the process of cancellation, to ensure that the replacement license or exim scripts were no longer transferred. The intent and purpose was not to purchase goods in the form of replacement license or exim scripts, but to nullify them. The said purpose and objective is the admitted position. The object was to mop up and remove the replacement license or exim scripts from the market. 39. Be it noted that the initial issue of is not treated as transfer of title or ownership in the goods. Therefore, as a natural corollary, it must follow when RBI acquires and seeks return of the replacement license or exim scripts with intention to cancel and destroy them, the replacement license or exim scripts would not be treated as a marketable commodity purchased by the grantor. Further, SBI is an agent of RBI. The principal, the exim scripts of replacement license were not goods which were purchased by them. The intent and purpose was not to purchase the replacement license because the scheme was to extinguish the right.
But here there was a sale to SBI.
Yes.
In your case.
No, we have surrendered to it. It is my case that I have surrendered the license.
But look at para 7, page 33. The question itself is formally you have sold.
Yes, the modality of the transaction, exim scripts, REP license linked with the payment of premium by SBI, the contention of the petitioner that it is only a surrender. It is only a surrender. It's not a sale.
That is clear from page 28. Come to page 28. So it is only a surrender. All right. You see, this appeal is directed against an order dated 12 January 2007 passed by the Commissioner of Commercial Taxes, Cuttack, in revision case number BH-2-4/97-98, whereby the order dated 31st August 1995 of the First Appellate Authority, allowing the appeal filed by the present appellate SSC and reducing the impugned assessment and directing refundable amount of rupees 362,485 was sought to be revised suo motu. Paragraph. The reason for exercising the suo motu revisional power was that the appellant had allegedly suppressed turnover relating to sale of single quotes exempt scripts unquote for the year 1991-92. And this factor was not considered by either in the original assessment order dated 15th December 1992 or by the First Appellate Authority in the order dated 31st August 1995. Paragraph. It was specifically contended before the Commissioner by the present appellant that it had merely surrendered the exempt scripts to State Bank of India, bracket SBI, and that such surrender of the exempt scripts would not attract the description of single quotes sale, unquote. And therefore, no tax liability arose as a result of such surrender of exempt scripts. Paragraph. The above contention was negatived by the Commissioner in the impugned order. Paragraph. The question whether the mere surrender of exempt scripts would attract the definition of single quotes sale was considered by the Supreme Court of India in Commercial Tax Officer with State Bank of India, 2016-10 SEC 595, in the context of expressions used in the Bengal Finance bracket Sales Tax bracket Act 1941. Full stop. There, the Supreme Court has categorically held in para 38 of the judgment is under. This reproduce para 38. Paragraph. In the present case, it is not disputed factually that the appellant had merely surrendered the REP license, right?
Yes.
To SBI. REP license / exempt scripts. to SBI. And this was not a sale, which should make it liable to tax. Full stop. Since the position is now settled by the aforementioned decision of the Supreme Court of India, the court has no hesitation in setting aside the impugned order. Full stop. Paragraph. Full stop. It is so ordered. Full stop. Paragraph. Since the matter has been decided on merits itself, the court is not considering the other plea raised by the appellant, that the reopening of the matter by way of a suo motu revision was itself time barred. So that question is left open for decision in some other appropriate case. The appeal is accordingly allowed. No orders.
Item 2.
Yes, my lord. My lord, in item 2, my lords, I am covered by my lord's order, wherein my lord says that in absence of any cognitive evidences that there is a suppression of sales and the goods have been sold, that only in comparison with the book balance on I estimation with the physical stock available, that cannot be held. There is a suppression with resorting to best judgment assessment. In the case of Gupta Distributor, Lord, decided on my 22nd of March 22 to my lord. And let me place the order, my lord.
Questions 2 and 3.
Para 6 and 7, my lord. Sorry, para 7 and 8, page 3, my lord. Para 7, my lord. Page 3, my lord. I may read out, my lord?
Yes.
The main charges against the RCC was regarding unexplained stocks. As explained by this court in the Lakshminarayan Swarnalam versus State of Orissa, order dated 20th of July 71, in OJS number 286 of 1968, unless the department is further able to show that the suppressed stock was sold by the RCC, there cannot be automatic enhancement of the taxable turnover. 8. From the aforementioned reasons, this court is unable to sustain the reasoning of the tribunal for resorting to the order of the STO and reversing the order of SCST. The question framed this court is answered in the negative by holding that the enhancement of turnover in absence of any material to establish the goods found short have been sold is neither lawful nor valid, is contrary to the law explained by this court in Mahavir Rice Mill Supra, my lord. This case, your lordships, there is no question of your lordships. Any suppression have been detected either by you of tangible evidence, your lordships. Neither has been item of evidence brought to the record that the goods have been to sold, the manner of dispute, the manner of any allegation only.
All right. Yes, what do you say?
My lord, ask my page 11, assessment order. After the tabular from Para. The dealer was confronted to the allegation in the audit visit report submitted by the audit team of the circle, in which suppression of such is detected during tax audit for the year 2005-6-7-8 up to 29/8/2008. The audit team visited the business premises of the dealer on such day. The discrepancies observed in the audit are as follows. Then the last two lines. Taking the above discrepancy in stock figure into account, the audit officer submitted the AVR regarding the total submission and both purchase and sale. This is important, my lord.
This is only calculation, my lord. Only
of the
because
tune
the
of
stock has been detected on I estimation basis. On the balance sheet, they enhance the margin by incorporating the profit margin, your lordships. Except then there is no other evidence is brought on record, my lords. Only on basis of book balance and physical stock available, your lordships.
This is the finding of ABR and
there's no finding that he has sold it. That seems to be the Mahabir rice mills.
I'm obliged, my lord.
Right. You see, admit the following question of law. It's all been admitted. All right. While admitting the present revision petition on 27th April 2015, the following questions were framed for consideration. Then below, after that, you say take from page 7, 2 and 3. It is seen that the assessment was finalized on the basis of the audit visit report, which allegedly found suppression of both purchase and sales figures to the tune of rupees 284.00. Full stop. Counsel, the petitioner points out that this was on the basis of I estimation and not on the basis of any concrete material. Full stop. In particular, reliance is placed on the decision of this court on 22nd March 2022 in STREV 2 of 2008, bracket Messrs. Gupta Distributors Cuttack, the state of Orissa, to urge that unless the department is able to show that the suppressed stocks were sold by the, there cannot be an automatic enhancement of taxable turnover. Paragraph. Counsel for the department referred to the observations in the order of the assessing authority regarding detection of suppression of both purchase and sales figures. Purchase and sales as detected by the audit team. Stop. The fact, however, remains that there was no corresponding finding that the suppressed stocks were in fact sold by the SSC. So, in similar circumstances, in Lakshminarayan Savalram versus State of Orissa, bracket order dated 20 July 1971 in OGC number 286 of 1968. And Mahabir Rice Mills versus State of Orissa 1980, 54 STC 218 bracket Orissa bracket. It was held that in the absence of any material to establish that goods found short have been sold, there cannot be an automatic enhancement of the taxable turnover. Paragraph. In light of the legal position explained above, the court has no hesitation in setting aside the impugned order dated 31st March 2009. No. What is it?
March.
12th October 2012 of the Orissa Sales Tax Tribunal in essay number 72 bracket P80 of 2010-11. For the tax period 1st April 2005 to 31st March 2008. Full stop. The petition is accordingly allowed.
And be obliged.
With circumstances, no orders is to cause.
Item 3.
Item 3, my lord, the question already admitted by this honorable court at page 14. Question number 1. Whether on the facts and in the circumstances of the case, the tribunal is not justified in reversing concurrent finding of the assessing authority as well as the first appellate authority and the order passed in second appeal is purpose when it was held that royalty is not included in turnover of purchase for the purpose of determining. Yes, my lord.
So the revision has to be dismissed, correct?
No, my lord, it's in my favor. State is before
Just
you.
see that so many negatives. And
my lord,
question number 1, whether the tribunal is not justified in reversing concurrent finding.
Concurrent finding of the assessing authority and the first appellate authority.
Where it was held royalty is not includable. This tribunal held it was not includable.
Yes, my lord.
Oh. Has the other side been served? Appearances. One Miss Natabar Mohanty has been appearing. Mr. Natabar Mohanty was earlier appearing, advocate was earlier shown as appearing for the respondent. Today, however, none appears. Paragraph. The present revision petition by the state was arising from an order dated 2nd March 2013 of the Orissa Sales Sector in SC number 1413 of 2006-7 relating to assessment year 2002-03. Was admitted by this court by an order dated 18 November 2015, and the following questions were framed for consideration. Paragraph. The above questions are no longer res integra and appear to have been decided in favor of the. But this was there even when the tribunal passed the order, this judgment. Wasn't this judgment? Because this is a judgment of 2007.
Yes, my lord.
So how come this was not shown to the tribunal?
That time they could not able to show the state representative.
You see, the question is no longer appears to have been decided in favor of the department and against the SSC by this court in DCH Guruvalu, Son and Company was the sales tax officer, Koraput 2 Circle, 2008-14 PST 509 bracket ORA. Also, it is categorically held by this court that royalty was includable in the taxable turnover for the purpose of payment of tax. For the Orissa Sales Tax Act, 1947. Paragraph. For the aforementioned reasons, the questions framed above are answered in favor of the department against the SSC. In other words, the impugned order of the tribunal as far as the above two questions are concerned, is set aside. So the revision petition is disposed of.
Item 4.
May I please, Your Lordship? By order dated 3/11/2016, this Honorable Court has been pleased to admit the sale tax revision on the following question: whether the tribunal is justified in confirming the reversal of input tax credit by applying subsection 8A of section 20 of the OBT Act on the account on the amount received towards credit notes from the different companies based on, my lord, this is important, achieving the business target where no input tax credit was involved in such credit notes. Where input tax credit is involved, then section 28A would be applied. Your lordship kindly see section 28A at page 14 of my paper book. May I read, my lord?
Yes, please.
Where sale price of any taxable goods for any region is less than the purchase price of the said goods, the input tax credit or purchase of such goods shall be allowed only to the extent to the output tax payable on the sale of such goods, and in such case, if the input tax credit has been availed in excess of the output tax paid or payable, it shall be reversed in the manner prescribed. From the above aforesaid provisions of law, it emerges that the aforesaid provisions of law relate to input tax credit taken by a dealer if sale price of a taxable goods was less than the purchase price. Then the input tax credit would be allowed to the extent of output tax payable on sale of such goods, and if the ITC was availed in excess of the output tax, it shall be reversed. But in the instant case, the credit notes issued by the principal companies to the petitioner does not involve any input tax credit, nor the credit notes were issued in respect of any tax invoice, nor the sale price of the goods was less than the purchase price of the goods, and accordingly reversal of so and so from claim of ITC was without jurisdiction and without authority of law, and the aforesaid provisions of law has been misinterpreted and misapplied by the learned tribunal. Your lordship may kindly see the credit notes at page 20. One series. Performance incentives. Nothing to do with ITC, no tax invoices involved in this. But unfortunately, the tribunal passed, the appellate authority allowed the appeal. Appellate authority allowed the, but the learned tribunal has misinterpreted the aforesaid provisions of law. The tribunal order is at page 48, my lord.
Yes.
Last paragraph. The dealer respondent has received the credit notes amounting to so and so, and because of such incentives in the form of credit notes, the sale price of some items is less than the purchase price of the said. It is totally misinterpretation, totally misleading, my lord. My credit notes were issued for my achieving sale target. This is nothing to do with the credit note. So the tribunal has passed the order without clearing my credit notes. Annexure 1 series at page 20.
That fact is not in the record. That whether it was a discount or credit note has been issued as a discount or the reversal of the sale price. It is clear finding of the tribunal, my lord. I am reading the total order. That page 48 of the tribunal's order. Below 4 lines, the dealer respondent has received credit notes amounting to rupees such, and because of such incentives in the form of credit notes, the sale price of some items is less than the purchase price of the said goods. The input tax credit on purchase.
He says this is completely wrong. This is what he's trying contesting. He says this is not based on any material whatsoever. This kind of a finding. No point in reading it. That's what he's saying is wrong.
But he has to show that he has received those credit notes regarding discount, that trade discount or anything like that. He has to show that.
Where are your submissions before the tribunal? You put it down in the form of an affidavit? What did you do?
My lord, your losses will see the first appellate order at page 43, my lord.
Yes.
Second paragraph, my lord. Thirdly, as regards receipt of credit notes of rupees 39,02,681 from different companies, the question of reversal of ITC for the above amount is not conforming to the rules under the OBAT Act. In this connection, the learned assessing officer has stated in his assessment order as per subsection 8A of section 20 of the OBAT Act, where that is the quotation, my lord. Then the learned assessing officer, in pursuance of subsection 8A of section 20 of the OBAT Act, reverse ITC of so and so from the total ITC claimed by the dealer. Further, he also excluded the carry forward ITC of so and so. In order to examine the above matter, reference was made to subsection 8A of section 20 of the OBAT Act, which is reproduced below. My lord, thus from the next page, my lord. Thus, from the above extract of section 20 and 21, read with other subsection, it is very much clear that the learned assessing office has not acted as per provisions of law of OBAT Act and the rules, and has interpreted the provisions of the Act in his own manner, which is not sustainable in the eyes of law. Further, in order to promote business, different dealers adopt different popular schemes to attract customers, which is very much common. And in case of free gift of stabilizer, the dealer has purchased stabilizer from registered dealer in retail invoice and has not claimed input tax credit and has given it to his customer as free gift for promotion at business and maintain this transaction in his business promotion account. Therefore, it cannot be treated as purchase operation.
That is regarding suppression, but regarding that credit notes, it's a incentive.
By this deputy commissioner. Just put it to
Mr. Mahanti.
My lord.
Section 22 will have no impact on this.
Yes, madam. No impact. That is why the first appellate authority allowed. But the credit note stipulated in section 21-22 has no bearing at all. My lord, I have claimed the input tax credit without any reversal, without any bearings on the credit notes. The learned tribunal has not examined the Annexure 1 series at all.
Mr. Mahanti, proviso.
My lord.
Proviso to section 22.
That no such adjustment shall be allowed in respect of such tracts where any credit note has been issued as a consequence of cash discount of sale insult. My adjustment, my most respectful submission, no such adjustment shall be allowed in respect of such tracts wherein the credit note has been issued as a consequence of cash discount or sale discount. My adjustment has nothing to bear with credit note, my lord. That is why I am not coming on the appropriate proviso.
No, your credit notes are not relatable to any discount or incentive.
No, credit note has no bearing at all to the input tax credit. This proviso is relatable to input tax credit. My lord, adjustment of input tax credit. I have not taken any input tax credit, nor I have adjusted any input tax credit in respect of this credit note. This is only performance guarantee, performance for achieving performance, my lord. The tribunal has not considered at all. What I suggest, let the tribunal decide this.
Or the petitioner SSC has in this petition questioned an order dated 19 June 2013 passed by the Orissa Sales Tax Tribunal, Tribunal, Cuttack, in essay number 59, 5 of 2012-13, whereby the appeal filed by the revenue was allowed and an order dated 28th April 2012 passed by the DCST Appeal Cuttack deleting the demand raised by the sales tax officer, Cuttack 1 City Circle, for the period 1/4/2009 to 31st January 2010 was set aside. Paragraph. The net effect of the impugned order of the tribunal is that the demand raised by the STO for the aforementioned period has been restored. Paragraph. While admitting the present revision petition on 3rd November 2016, the following question was framed for consideration. Reproduce the question. The background facts are that the petitioner SSC big dealer registered under the Orissa Value Added Tax Act 2004 (OVAT Act) carries on business in trading of electronics and electrical home appliances within the jurisdiction of the Assistant Commissioner of Sales Tax (ACST) Cuttack -1 City Circle. Full stop. It is stated that the dealer is carrying on the business of trading in the above goods by purchasing them inside the state of Orissa on payment of the requisite VAT, which under the law has to be adjusted against the output VAT. Paragraph. It is stated that returns were filed for the aforementioned period by the dealer and no assessment order was initially passed. Full stop. However, notice was received by the petitioner from the assessing officer under section 43(1) of the OVAT Act, alleging that the petitioner had not paid any output VAT from April 2005. Full stop. On the other hand, carry forward of income input tax credit (ITC) to the tune of rupees 580,689 was shown as on 1st February 2010. Full stop. Among the other things noticed was the receipt of credit notes from different selling companies during the aforementioned period. During the period April 2009 till January 2010, which was not reflected by the dealer in his books of account. Accordingly, it was contended that accordingly, it was stated in the tax evasion report that ITC on rupees 39,02681 had to be reversed under section of the OVAT Act on the ground that sale price of the goods would be less than the purchase price due to grant of incentive in the form of credit notes. Paragraph. Paragraph. In rejecting the plea of the dealer, the tribunal appears to have referred to section 20 bracket 8 dash small a of the Overt Act, which inter alia states that if the ITC that has been availed is in excess of the output tax paid or payable, it shall be reversed in the manner prescribed. Paragraph. Further, in terms of the proviso to section 22 of the Overt Act, no adjustment of ITC shall be allowed, open question, where any credit issued as a consequence of cash discount or sale incentive by any registered dealer to another registered dealer after the tax invoice is issued, unquote. Paragraph. Although the claim of the present petitioner is that the credit notes issued by the principal companies to the petitioner do not involve any ITC, nor were the credit notes issued in respect of any tax invoice. And the sale price of the goods was not less than the purchase price of the goods. Full stop. It was accordingly contended that the reversal of rupees 487,835.12 from the claim of ITC was without jurisdiction and without any authority of law. Paragraph. The court finds that there is no determination on a factual basis whether the ITC as issued by the principal companies to the petitioner for achieving the business target were not credit notes as defined in section 23, read with section 22 of the Overt Act. Paragraph. There is no factual determination of the above aspect to enable this court to appreciate whether the tribunal was justified in its conclusion. Paragraph. Since these issues purely turn on facts, it was necessary for the tribunal to have embarked on a factual inquiry before arriving at the conclusion which has been challenged in the present revision petition. Paragraph. Accordingly, the question framed is answered by holding that the tribunal should revisit the entire issue in the light of the available materials and any further documents that may be placed by the party for it on remand. We'll stop. The tribunal is accordingly set aside, and the matter, that is essay number 59 bracket 5 of 2012-13 bracket State of Orissa versus Messrs Gupta Distributors bracket will stands restored to the file P. Tribunal to be now proceeded with in accordance with law. The matter will be listed before the tribunal for directions on 30th January, 30 January 2023, on which date dealer will be present through either an authorized representative or an advocate, and the department by its standing counsel. The tribunal is requested to dispose of the matter afresh after hearing the parties in accordance with law as expeditiously as possible and preferably within a period of 6 months thereafter. The LCR, if not already returned, be returned forthwith to the tribunal.
Item 5.
May it please your lordships. My lords, the petitioner before lordship is a manufacturer of this atta, maida and suji. My lords, what happened for the period November 2006 to February 2008, he was assessed by the assessing officer who relied on a circular of the government of
So the
Odisha.
demand is 60,498.
No, whereas the penalty is there. Succeeded before the first appellate authority. He deleted the penalty. Tribunal substituted the order of the assessing authority, only penalty. And my learned friend has also agreed to the proposition that penalty should not have been imposed.
As per my lord's order.
Penalty, what the penalty? 1,27,000 is the penalty. This has been admitted. Only penalty portion, my lords.
40-5 penalty, my lord.
So you can't even waive it,
my lord.
What to do? You say admitting the present revision petition on 8/9/2014, the following question was framed for consideration by this court. Oh, but the question is not on penalty, sir.
No. Question is not about penalty. They have just admitted it, my lords, and stayed.
No. Whether the tribunal is justified in placing reliance on a circular.
Circular, yes. Circular. Correct, my lord. Circular is of the year 96. And at that time it was issued because it was issued for the storage agents. Who are the storage agents for the wheat? Now, I am not a storage agent. If the assessment is for the latter period, it was only for that period only. Okay. So the applicability of accepting the circular, nothing else is there. And the learned appellate authority lordship will kindly see at page 16 or 7. Yes, 16. Now coming to the other portion of the dispute raised by the SC/ST regarding production ratio, I am of the opinion that the circular issued by the Civil Supply Department is an old one. Full stop. Moreover, the dealer appellant has shown total output at 76% of the raw material used, which is slightly below the ratio discussed. Therefore, this portion, next page, enhancement by the learned SC/ST is now deleted. He after delete.
And the state went in appeal.
Yes, state went in appeal. And the tribunal said that the circular of the government of Odisha will hold good. Para 6. So far as the calculation of ratio of production, the learned AO accepted the approval ratio fixed by the government of Odisha. On the other hand, the first appellate did not accept the same and accepted the ratio shown by the dealer. In my opinion, since one approved guideline has been made by the government, it should be accepted. Otherwise, there would be anomaly regarding the ratio production by the dealer. And the dealer would have different
Which
ratio
is that
production.
circular? Where is that referred to?
Page 11. Page 11 that has been called out by the assessing authority.
Yes.
Page 11 of the assessment order.
Yes.
Secondly, as regards production ratio, the dealer's claim of ratio is not acceptable at this end. As per clause 3 of Food Supplies and Consumer Welfare Department, Government of Odisha, the roller flour mills will mill atta and deliver FAQ standard of suji, maida, and atta at the rate 5%, 35%, and 30%.
Respectively.
Which is for which period?
That is for the period, man, 94, 96, my lords.
That is still continuing.
96.
That is still continuing.
Where is your evidence that it is still continuing? Where is your evidence?
These prices, they keep on fluctuating.
Yes.
You can't have it forever.
96, and the assessment is for the period 2006 and 8.
So
10 years after, you will continue with the circular.
Yes, wheat is always same as wheat.
No, price.
Price.
This is not price, my lord. This is the loss.
Loss.
Whatever, sir.
This is the production ratio.
Yes.
Yes. At that time, this circular was issued because of the wheat, they are the storage agents.
This is not roller flow mill.
In order to have a check that circular issued for the, not how can, where, and that question has never been raised by the appellate state before the tribunal, that it still holds good for time immemorial.
Where is that original document? That is not there.
No.
Reference is made to it.
My lord.
So what? We don't even know how that circular says. We don't even know what that circular says. What is the date of the circular? Nothing we know. Was it meant to apply beyond 96, like he's saying? What is the circumstances in which it was issued? In fact, it simply says, as per clause 3 of the Food Supplies and Consumer Welfare Department. It can't be clause 3 of some circular must be. No, but where is that? We need the text of that circular. So without the text of the circular, how do we simply say that it was meant only for storage agents and all? We need that actual circular.
I quite appreciate, my lords, but I think somewhere in the grounds, your lordship will kindly see that I have mentioned it. Page 15. Page 15, paragraph D. When filing the appeal matters, I have mentioned circular is issued by number EC.1. As per the direction of the government of India, effective to that period only. At that point of time, the flour mills were allowed as storage agents of wheat, so that the ratio of production prescribed in that circular will be binding on them. During the period under dispute, the appellant was not a storage agent of wheat. Therefore, the circular is not binding. And
see the challenge in the present revision petition by the SSC dealer is to the order dated 1st August 2013 of the Orissa Sales Tax Tribunal, allowing SA number 44 bracket VAT of 2012-13 filed by the state against an order dated 21st April 2012 passed by the Additional Commission of Sales Tax Appeals in first appeal case number AA 132 /V, not bracket V /ACST /BA /09-10. Full stop. Paragraph. The first appellate authority had allowed the appeal filed by the dealer and reduced the demand to rupees 60,498 for the tax period 1st November 2006 to 29th February 2008, thereby modifying the assessment order passed by the Assistant Commissioner of Commercial Taxes, bracket ACCT, raising a demand of rupees 220,713 and penalty of rupees 147,142 under section 42, bracket 5 of the Orissa Value Added Tax Act 2004, bracket OVAT Act. Paragraph. The background facts are that you say, while admitting the present revision petition on 8 September 2014, the following question was framed for consideration. Paragraph. The background facts are that the petitioner dealer is registered under the OVAT Act and is engaged in the manufacture and sale of atta, maida, and wheat bran. For that purpose, the petitioner purchases raw material, that is wheat, both from outside and within the state for milling. The petitioner claims to be maintaining its books of accounts, which includes the purchase register, purchase voucher, sales register, etc. Paragraph. Although the petitioner produced its books of account before the assessing officer, the latter came to the conclusion that the petitioner had suppressed sales to the tune of rupees 326,816 and accordingly determined both the tax gross turnover as well as taxable turnover, thereby raising a demand of rupees 220,713. In the course of the said determination, the assessing officer placed reliance on a circular number EC 1.7/94.43861 dated 6th December 1994, issued by the Food Supplies and Consumer Welfare Department, Government of Orissa. So, according to the petitioner SSC, the said circular was issued at a time when flour mills were allowed to also be storage agents of wheat. So the said circular prescribed the ratio of production of suji, maida, and atta at 15 No, from wheat, from 1 quintal of wheat. So in other words, it was determined therein that for milling 1 quintal of wheat, a miller can get 30 kg of atta, 35 kg of maida, 15 kg of suji, and 19 kg of bran. And the production loss would be 1 kg. Stop. On this basis, it was determined that the claim by the dealer that its ratio of production was 76% taxable, 23% tax exempt, and 1% loss was only was not so material a difference so as to reject the figures found in the books of accounts of the SSC. Paragraph. This contention of the SSC, dealer SSC, that the said circular would not have any application was accepted with the first appellate authority. Full stop. The total output shown by the SSC at 76% of the raw material was held to be only, open quotation, slightly below the ratio discussed. Unquote. Further, first appellate authority noted that, open quotation, no discrepancy in the physical stock position could be gathered at the time of spot verification, and neither any sales suppression nor purchase suppression have been alleged. Unquote. And that in those circumstances, open quotation, the books of account cannot be rejected on the basis of mere suppression. Unquote. Paragraph. Having heard and consulted the parties, the court was the view that both the assessing authority and the tribunal appear to have placed considerable reliance on the aforementioned circular of the Food Supplies and Consumer Welfare Department, without appreciating the context in which it was issued way back in 1994. We'll stop. If, as pointed out by the SSC, it was meant to apply to flour mills which were also storage agents of wheat, then certainly that could not have been applied in the present context, where the petitioner dealer is not a storage agent for wheat, but only a manufacturer of atta, maida, suji, etc. Full stop. Secondly, where the books of accounts maintained by the SSC is not shown to be erroneous and not rejected, the assessing officer could not have straightaway applied a circular of 1994 to determine that there had been suppression of purchase and sales. Full stop. Thirdly, as pointed out by the first appellate authority, even applying the circular, the figures disclosed by the dealer, SSC, were only slightly less than the ratio in terms of the above circular. Ratio of production in terms of the circular. Full stop. Viewed from any angle, therefore, there was no warrant in the conclusion there had been suppression of sales by the dealer SSC. Full stop. For the aforementioned reasons, the question is answered in the affirmative in favor of the petitioner. No, in the negative, that is in favor and against the department. Stop the impugn order of the tribunal is set aside and the order of the first appellate authority is restored to file. So the consequential order of penalty is also hereby set aside. So the revision petition is allowed in the above terms, no assistance.
Much obliged. Much obliged.
After lunch.
Item number 6, my lord, Mr.
Is unwell, is it? All right. It will stay on board.
Is other cases.
That
is other,
25,000 has been deposited.
my lord?
You saw the noting in the cause list. Receipt showing deposit of 25,000 not received.
Actually, I don't know.
See, the stay was granted subject to petitioner depositing 25,000. Is the receipt there? No. Not received. The office noting is that there is no receipt by the petitioner as proof of having deposited 25,000 within 4 weeks of 15th July 2015, the date on which the conditional stay order was passed. It is made clear that if the proof of such deposit is not produced, the stay order and automatically vacated.
28,000 deposit.
And then we say counsel for the petitioner state should be unwell. List in the miscellaneous matters, not in the main board. List in the miscellaneous matters on
28,000 deposit.
18th April.
Item 7.
Admitted by this honorable at page 29.
The mic has to be on.
The question of law is at page 29. G has been admitted, my lord, whether on the facts and in the circumstances of the case, substitution of entry 136 of the list of goods subject to sales tax under the Orissa Sales Tax Act.
Woven sacks, HDP is covered.
My lord, Here it is SDP fabric. Page 3, my lord, has called out the entry.
Para 20 is the answer.
Yes, my lord.
All right. In judgment dated 20th July 2021 of this court in STREV 1 of 2021 bracket, Mrs. Tharatarini Rubber India Private Limited was the state of Orissa. The question framed by this court in the present revision petition on 23rd February 2015 is answered in favor of the department and against the SSC. Full stop. In other words, the impugn order of the tribunal is set aside and the assessment order is restored to fact. The revision petition is disposed of.
Item 8.
8 and 9, my lord. Revenue implication is all the.
Sorry.
Revenue implication is very low.
In view of the low tax effect, the court leaves the questions of law open for some other appropriate case and disposes of these revision petitions. The LCR be returned forthwith. 8 and 9 also same thing.
9, I'm appearing on behalf of the opposite party.
All right. All right.
Item 10.
May I please, Lords? Here on 28/1/2016, my lord, while admitting, my lord, the substantial question of law was framed. 28/1/2016. Sorry,
28/5/2016.
18/5/2016.
Yes, madam. Yes. Whether in absence of element of any willful or contumacious conduct on the part of the Union of India and any material to establish.
What's the penalty amount, sir?
Penalty, some that is in crores, my lord. Penalty amount.
In this case, 98.
98 lakh something.
Have you paid the penalty?
My lord, what happened, my lord?
There's no stay granted here.
HSD diesel was transported to the state, my lord. Railway was under the impression that it is not coming within the purview of anti-tax, my lord. That matter was challenged before your lordship, and your lordship has come to say, yes, it is coming within the purview of anti-tax. Then matter went to Supreme Court. Bona fidely, my lord, penalty was our penalty only.
My question is, have you paid it or you have not paid it? No stay granted here.
Yes. Stays there on 28/5/2016. Stays there, my lord. Miss case number. Stays there.
Where? Where is stay?
Yes. In other matter, past matter 103, my lord, in 103, my lord, your lordship, 18/5/2016, your lordship has leased this matter 4 weeks along with ST division, other matters. In other matters, stay has been granted, my lord.
Where is that?
Yes, my lord, those matters have come along with this matter, my lord. That is ST division number 104 of 2014, 99 of 2014.
You've not even seen the, 28/1/2016. Okay. Penalty is automatic, no? Because of 42(5).
This is 42(5), my lord. This is
No, sir, there's no corresponding section in Entry Tax Act.
No, my lord. This is earlier to.
This is earlier to back into this period. It is 7.5.
Yes. What is your submission? Was penalty justified or not?
I'm just reading out that provision, 7.5 provision.
OET Act.
My lord, in this case, what I gather, assessment has been made. Sorry, my lord, assessment under section 10(3) has been made without any assessment under section 9.
ECMAS. So that question is not framed, but thanks to Mr. Mohanty, it will never get framed. They didn't anticipate our judgment then. All right. It can go on that ground also.
My lord.
Original assessment itself, although you have come only under penalty orders.
Yes, ma'am.
He's come only on the penalty orders.
Yes.
So section 7.5.
My lord.
No, it's not automatic. That's the only question.
According to his return file, if he is not paid.
Not this. Before,
While making an assessment. May also direct. Okay. All right. Common question of law has been framed in all these revision petitions by the railways. Railways, right?
Yes, ma'am.
Namely, whether the imposition of penalty on the petitioner by the impugned order of the assessing officer as affirmed by the first appellate authority and the tribunal was justified. Question mark. It is seen that the original assessments were framed on the basis of the understanding of the railways, was made on a certain, under the Orissa Entry Tax Act 1999. On high-speed diesel received at various railway consumer depots. Full stop. The understanding of the railways was that it would be exempt from payment of such entry tax by virtue of Article 285 of the Constitution of India, read with Section 184 of the Railways Act 1989. Full stop. The assessment orders raising demands were unsuccessfully challenged by the railways, both before this court and the Supreme Court of India. Paragraph. Since this was in the early phase of the introduction of entry tax, the lack of clarity on the part of the railways was understandable. Full stop. On dismissal of the appeals by the Supreme Court, penalty under Section 7, bracket 4 of the Act as it then stood. Here it says 4. Para 6. Okay, 7.4 read with 7.5. You say, okay, 7 bracket 5 of the OET Act was imposed. And this has been challenged in the present round before the tribunal, again unsuccessfully. Paragraph. The failure by the railways to file returns under the OET Act and to collect entry tax was understandable and cannot be said to be deliberate or willful. Full stop. Under Section 7, bracket 5 of the OET Act as it then stood, there was an element of discretion in the assessing authority to require the dealer to pay penalty. Full stop. In other words, it was not automatic or mandatory. Paragraph. Keeping in view the above legal position under the OET Act as then stood, and in light of the facts explained here and before, the court is of the view that the levy of penalty on the petitioner by the authorities for the years in question was not justified. Paragraph. For the aforementioned reasons, the questions framed in these revision petitions are answered in favor of the petitioner railways and against the department. And the impugned orders of penalty imposed on the petitioner by the assessing officers, as affirmed by the first appellate authority and the tribunal, are hereby set aside. The revision petitions.
All the cases.
Yeah. Put them all together.
Item 11.
Lord, question is admitted here, but the liability, tax liability of the dealer, as per the assessment order, is 26 is 1,27,000 1,54,680 and penalty twice as been levied. My lord, when the huge amount of ITC available there, without adjusting the ITC, penalty is levied. This is a short question, before my lord.
42.5 penalty, my lord?
Automatic, sir.
Huge amount, 2 crores above ITC is available there.
There's no mandatory requirement that ITC should be adjusted. There's no such requirement, sir. That's a separate issue altogether. No, why should ITC be adjusted for living penalty?
Section 21.
No, 42, sir. Section 42.
My lord.
Overtime.
My lord, section 21 may kindly look to. My lord, input tax credit exceeding tax liability. If the input tax credit of a registered dealer other than an exporter selling goods outside the territory of India determined under section 20.
What are you reading, sir?
My lord, section 21 of the OBT Act. 21.
Section.
If the input tax credit of a registered dealer other than an exporter selling goods outside the territory of India determined under section 20 for any tax period exceed the tax liability for that period, the excess input tax credit shall be set off against the tax payable under the provision of the Central Sales Tax 1956 for that period at the first instant, and if any balance input tax credit is still available, the same shall be carried forward for being set off against the tax payable for subsequent tax or period by that dealer. My lord, because of huge amount of ITC available there, because central prior to that it is 2006 and 7. 16/2000 central sales tax available ITC is there, amendment come, and huge amount is there. Without adjusting the same penalty,
this is silent on penalty. It's only talking of adjusting its tax level. Silent on penalty, sir.
Tax due is required to be adjusted towards ITC available. Then penalty comes.
No, but here, look at the question. Whether the tribunal is right in confirming the imposition of maximum penalty. It's not about adjusting ITC, sir. Just see the question. How the question has been framed. 8 September 2015.
My lord, whether on the facts and in the circumstance of the case, the tribunal was right in confirming the imposition of maximum penalty by the forums below, relying on the ratio of the decision rendered in the state of Jindal Stainless Limited versus State of Odisha and other reported in 54 BST 1, without taking into consideration the decision relied on by the petitioner rendered in the case of Union India versus Azam Limited reported in 2010 1 GSTR 66, which has been relied on by the Honorable Supreme Court in the case of Commission of Central Excise.
This is not about adjusting ITC. This is not the question. That's not the question framed, sir. And because of 42.5, now where is our decision on 42.5? While admitting this revision petition on 8 September 2015, the following question was framed. Take the question. Paragraph review of the decision of this court dated 5th July 2022. In ST REV 69 of 2012, State of Odisha versus Chandrakanta Jayantilal. The said question is answered in the affirmative, that is in favor of the department and against the petitioner SSC. The revision petition is accordingly dismissed.
Item 12.
Your name is states revision. The question is at page 12 of the revision petition, my lord. Question number A. Whether on the facts and in the circumstances of the case, the tribunal erroneously decided the issue by not considering the effect of section 15D of the Central Sales Tax Act 1956 in the context of obtaining dal from milling pulses. I'm just placing 15D, my lord, of the CST Act.
think this also is answered, sir. This dal from pulses, I don't know.
15D says each of the pulses referred to in clause of section 14 where whole or separated and whether with or without husk shall be treated as a single commodity for the purpose of levy of tax under that law.
Rohini Industries case.
My lord.
Rohini Industries case.
That's only has been framed, in fact.
Yes, my lord.
As the
You have got that copy.
All right.
The tribunal has held page 28 of the revision petition. We have carefully heard the matter from both the parties present.
No, that's there. It's enclosed as Annexure 4, Rohini Industries.
My lord. That order has been annexed, my lord. Page 37, my lord. The exemption as claimed by the petitioner under the notification is not applicable to the fact situation for the reason that the pulses which is said to have been purchased to procure dal after removal of husk from the pulse by undertaking the process work does not amount to manufacturing activities, as dal and pulses is a single commodity as stated in the aforesaid clause of the CST Act, which is an amendment of Central Sales Tax Act by Act number 103 of 1976 and has come into force with effect from 9 September 1976. Therefore, the reliance placed upon decision of the division bench of this court and apex court is misplaced, and they do not have lent any support to the case of the petitioner. The ratio and the law laid down in the aforesaid case is not applicable to the present fact situation, as clause D of the section 15 of the Central Sales Tax Act has come in force on 9/9/1976. Therefore, the submission of the Law and Council for
all right. While admitting the present revision petition on 14 January 2016, the following question was framed by this court for consideration.
Yes, may I interrupt for a moment with your lordship's permission? Yes, I have one matter which your lordship has adjourned to tomorrow. I was told that identical question is involved. I don't.
That dehusking.
Dehusking, dal.
But it seems to be fully covered against, in their favor. That Rohini Industries is for
Exact question, but I think identical.
Yeah, in Rohini Industries you appeared, but they did not agree with you. 1st December 2011.
Rohini Industries. Anyway.
All right. The order passed by this court on 1st December 2011 in STREV 96 of 2011 bracket Messrs. Rohini Industries was the state of Orissa has been perused. Stop. There, this court categorically held that the exemption claimed by the petitioner on a notification dated 31st March 2001 issued by the state government under section 8 bracket small b of the Central Sales Tax Act 1956 bracket CST Act stating that sale of goods enumerated in the notification in the course of interstate trade or commerce by a dealer having his place of business in Odisha shall be calculated at the rate of 1%, subject to production of the C form, would not be available to the dealer in that case. Other than that, the pulses said to have been purchased to procure dal after removal of husk from the pulse by undertaking the process work, open quotation, does not amount to manufacturing activities, as dal and pulses is a single commodity. Unquote, as stated in clause 50, section 15, bracket D of the CST Act. Full stop. In that view of the matter, the question framed by this court in the present case is answered in the affirmative, that is in favor of the department and against the SSC, and the impugned order of the tribunal is hereby set aside. The revision petition is allowed in the above terms. Both these same.
My lord, same. 14 is also same, my lord. Same question.
Yeah.
14. Yes. Sorry, my lord. 13.
13 is the same?
Yes, my lord. Question A at page 14.
All right. In view of the decision, the court today in STREV 128 of the 2014, the present revision petition is allowed with the same terms. And the question framed is answered in favor of the department and against the SSC. So the impugned order of the tribunal is set aside. Right. 14.
Item 14.
Question of law, my lord. By order dated 4/11/2016, this surtax revision is admitted on the following substantial questions of law. Whether the tribunal is correct in upholding the levy of entry tax at the rate of 2% on furnace oil. Admitted furnace oil falls under entry 7 of part 1 of the schedule appended to the VAT Act, which is exigible to tax at the rate of 1%. Next question, my lord. Whether the tribunal is correct in upholding the levy of entry tax at the rate of 2% on HDPE bags. Admittedly, when HDPE bag falls under entry 23 of part 1 of the schedule appended to the VAT Act, which is exigible to tax at the rate of 1%. My lord, this was agitated before the tribunal at page 21. Tribunal has not passed any order in this effect. Your losses may kindly see page 21 of the tribunal order.
Yes.
Para 5. The appellant dealer being aggrieved by the aforesaid order of the learned DCST has preferred the second appeal on the ground that for that the assessment in question is wrong and illegal. For that the learned assessing officer or in calculating the entry tax on furnace oil and HDP bags for packing at the rate of 2% instead of 1%. Tribunal has not gone into this.
Oh. So it has to go back.
My lord.
While admitting the present revision on both November 2016, the following questions were framed for consideration by the court. Paragraph. It is seen from the impugned order of the tribunal in paragraph 5, bracket small b, that although the above questions were specifically raised before the tribunal, it has not dealt with the said questions in the impugned order dated 12th August 2014 in essay number 67 bracket ET of 2010-11 filed by the present petitioner dealer. Stop. Paragraph. Accordingly, the impugned order dated 12th August 2014 tribunal is hereby set aside to the extent that the tribunal has failed to answer the above two questions, and essay number 67 bracket ET bracket of 2010-11 is restored to the file of the tribunal for rendering a decision on the aforementioned two questions concerning the appropriate rate of entry tax on both furnace oil and HDPE bags as far as deal is concerned. The matter will now be listed before the tribunal for directions on 19 January 2023, on which date the petitioner dealer will appear either through an authorized representative or through a counsel. The tribunal's request is will endeavor to dispose of this appeal as expeditiously as possible, preferably within a period of 6 months from that date. The revision petition is disposed of in the above terms.
Item 15.
Well, sir, in this case, two questions are involved for Lordship's consideration. One is whether levy of tax at the rate of 12.5% lime powder under Part 3 Schedule B is just and proper, and whether suppression of 6,11,960 merely on plea of assumption due to absence of this is merely an admission they have sustained this, which is directly covered by a judgment of Lordship in Sai finance case. That mere admission of a dealer cannot lead to confirming suppression for levy of tax unless because the whole of the thing is governed by statute unless any taxable sales takes place inside the state giving rise to levy of tax, mere admission per se cannot lead to levy of tax. That is what your Lordship precisely said. And I am taking your Lordship's attention, kindly see page 23, page 23, how the SCST has dealt with the issue, page 23. Serial number 2, question number 2. Kindly see, regarding placing from the 4th paragraph, regarding cell suppression, page 23 of 6,11,962, as the dealer has admitted that the covered 3 number pocket diaries and 3 numbers written to be read to business, that is lime powder, the LAO established cell suppression at 6,11,962. This is the only point. At this stage, the authorized representative argued that the appellant submit that most of the entries of the seized documents are mere estimation and really no transaction have taken place, especially in 3 written slips in this context. So this is how. These are all estimations. Neither revenue has also failed to bring in record anything to establish that these are suppressed material. Now, you will also kindly see how tribunal dealt in. Page 27, only one line finding is there. One line finding, my lords will find at page 27, consider that is coming to the circumstances, page 28. 20, page 26. Cannot find the procedure for considering the second issue. The inspecting officer during inspection, SSIP has no duty to verify the cash position. This he has admitted. Yes, sorry. Coming to the next issues, there's 7-8 lines from the top. Coming to the next point of dispute, self-suppression amount to 6,11,962. We find that Lord DCST has categorically mentioned that admission of the dealer. So this one only, this portion, because there is admission, nothing else on record, he sustained. And your Lordship may kindly see my Lord's own judgment of this on report in the case of Sai Finance. Perhaps it is reported in.
Right.
My Lords.
You had it.
Para 28. Para 28. That will be my only submission, my Lord, so far as this issue is concerned.
What about that lime powder?
Lime powder, my Lords, that according to the petitioner, my Lords, that is covered under, my Lord, there is a specific entry. My Lords may kindly see, I have quoted, that is serial number 80 of Part B, Schedule B of Part 2. That is at page 10. Ores and minerals. Ores and minerals. There's a lime powder that comes from it. And my the officer from the department, he says that this is coming from a residual item under Schedule C, which is a residual item. So it is liable to pay 12.5%. But specific entry is there, it overrides all of the general entries below. It says ores and minerals. And that is lime powder. So many, apart from writings, writings,
that so many things are this particular lime powder is a mineral, even ocularly outside. But there are but I'm placing one. There are so many.
So if it is a mineral, then what is the rate of tax?
Rate of tax belongs is for ores and minerals, serial number 80, 4% belongs. If it comes residual, then 12.5.
I see.
And my humble sum, it comes from minerals, so therefore that's 4%. And one more thing.
12.5.
And my third submission would be, my lords, you also kindly see for moment page 17, my lords. This is an assessment, reassessment under section 43. At page 17, my lords, we kindly see for a moment, first paragraph. From the above discussion. It's a matter of jurisdiction at any point. From the above discussion.
Keshav Automobiles.
Case automobiles. The dealer is engaged
Even
in
the other party was saying that.
That is what. And there are own saying, they say that the returns filed by the petitioner rejected while doing reassessment. Now, just now. In reassessment, they are rejecting my return. The language, therefore, all books of account returns filed by him under section 39 of the OBA Act. In fact, returns are filed under section 33. But under 39, he is rejecting while passing reassessment.
All right. This has to go. All right. While admitting this revision petition on 23rd November 2015, the following questions were framed for consideration. Paragraph. As far as the first question is concerned, the relevant entry in part 3 of the schedule to the VAT Orissa Valley Tax Act. Part 3 schedule B. That is entry 21.
80 bills. 80.
Reads,
part 2 schedule B.
Yeah,
4%.
reads as single quotes ores and minerals, unquote. And the rate of tax is 8%.
4% bills.
4%, full stop. For all residual entries, for all others, other items, the residual entry is attracted and the tax rate will be 12.5%. Paragraph. Considering that the petitioner is dealing in lime powder, which is obviously a derivative of a mineral, the question of treating it under the residual entry did not arise. Full stop. Consequently, lime powder ought to have been taxed only with reference to entry number 80 of Schedule Capital B, Part 2 of the VAT Act, and taxed accordingly. Paragraph. The question is accordingly answered in favor of the SSC dealer. Answered in the negative, that is in favor of the SSC dealer and against the department. And it's directed that the rate of tax on lime powder would be
4%.
4%. All right. As far as question 2 is concerned, it is plain that there could not be a conclusion regarding suppression only in the admission of the dealer. Stop. This court in Shri International Finance Limited was the State of Orissa, 2008, 16 BST 193. Inter alia observed, let's say A to A. Consequently, this question is also answered in the negative. That is in favor of the petitioner dealer and against the department. Paragraph. Additionally, it may be noted that the original assessment in the present case was a self-assessment. And Demand was created in the reassessment proceedings under section 43 of the Stop. In view of the decision of this court in case of automobiles, this is State of Orissa. That citation. The impugned assessment order cannot be sustained even on that ground. For the aforementioned reasons, the impugned order of the tribunal is hereby set aside, and the revision petition is allowed in the above terms.
Deeply obliged.
Item 16.
16, my lord. Need some time to reconstitute the brief, man.
Stay on board. Let's just see what it is that will be easier for you to deal with it. No question framed yet. Admitted, sorry. Simply says admitted.
Let's vote with the also bit of paper. The entry is only paper. Paper including newspaper. Entry.
All right, stay on board.
Item 17.
My lord, I bring for the petitioner, my lord. My lord, the questions of law is on page 12. It is already admitted, questions not yet framed. Page 12 may kindly be seen, my lord. 1, 2. There are two questions, my lord. The first question no more survives because the Supreme Court in the case of Father Fernandez William has already upheld the judgment of this honorable court in Tata Steel and has held that the levy of entry tax on goods imported from outside territory of India is valid. So question number 1 does not survive. The second question is with regard to penalty, my lord. My lord, the tax was not paid by me, gaining bona fide impressions from various judicial pronouncements. In Kerala High Court, in the case of, my lord, Father Fernandez William held in favor of HSC. Then Guwahati High Court in Primus Packaging also held in favor of HSC. The full bench of the Honorable Tribunal, OSTT, also held in favor of HSC. This Honorable Orissa High Court thereafter, my lord, in 2012, for the first time held against the HSC. So there was divergent opinion, my lord, as far as the levy of the imported goods are concerned. So there was a bona fide reason, there was a reasonable cause. And my lord, under section, section 10.2, it is a case of escaped assessment. Under section 10.2, if there is a reasonable cause for not paying tax, then penalty would not be levied. My lord, kindly see the compilation, my lord. One compilation I have given to my friend who is in the court. That comparison may be seen, my lord. Kindly see, my lord, page 10, it starts section 10 at the bottom, my lord. And the relevant portions are on page 10, my lord. Subsection 2. Page 10, subsection 2. I am on the confining myself to the penalty only. It reads, my lord, if the assessing authority is satisfied that the escapement or under-assessment of tax on account of any reasons mentioned in the subsection 1 is without any reasonable cause, he may direct the dealer to pay in addition to the tax assessed under section 1 by way of penalty a sum equal to twice the amount of tax administratively assessed under this section. So, my lord, the phraseology without any reasonable cause means if there is a bona fide understanding or gain from the judicial pronouncement, or there is a bona fide reason, then penalty would not be levied, my lord. But Supreme Court judgment is also
got settled only later. See, only after all this, the question got settled in the Supreme Court. So that's bona fide only.
Till 2017, interest till date, if he has not paid the amount, he is enjoying that.
Yeah. You say
tax is already paid, my lord. Tax should pay.
Two questions have been urged by the SSC dealer in the present petition, arising from an order dated 29 January 2015, passed by the Orissa Sales Tax Tribunal, Tribunal in SA number 215, ET, bracket oblique 2013-14 filed by the petitioner for the period 1/4/2008 to 30/9/2011. The set questions read as under. Take from page 12, 2 questions. Paragraph. As far as the first question is concerned, the issue now stands settled by the decision dated 28th March 2017.
My lord, that is page 24, my lord. The date is, lordship, date is, my lord, 9th October 2017.
9th October 2017, the Supreme Court of India.
Page 24, my lord.
In Jindal Steel.
No, my lord. It is
Father William Fernandez, 2000.
Correct, my lord.
2021, 11 SCC 705.
Report so late, is it? 2021, 11 SCC 705. I know, it's still, usually they don't print it 4 years later.
Yes, my lord.
Consequently, the court declines to frame question number 1 as urged. Paragraph. As far as question number 2 is concerned, with the legal position having been settled only in October 2017, most of the dealers of the SSCs were under bona fide impression that entry tax was not payable on goods imported into India. Full stop. Therefore, it could reasonably be contended that till such time there is no willful or deliberate attempt by the dealer SSCs to evade payment of entry tax. Full stop. The court notes that under section 10 bracket 2 of the OET Act, there is an element of discretion in the assessing authority to levy penalty where the escapement or underassessment of tax open petition is without any reasonable cause, unquote. Since the court is satisfied that the non-payment of entry tax on imported goods by the petitioner cannot be said to be without reasonable basis. The court is of the view that in the present case, the levy of penalty was not just.
My lord, can you have a glimpse of page 136, my lord? Kindly have a glimpse. Page 136 of the compilation, my lord. The same phraseology was before the Honorable Supreme Court in the Constitution bench. Same phraseology, without reasonable cause. Page 136, last 8 lines.
You're already answering it in your favor.
My lord. If you lordship feels equal, lordship.
The question is accordingly answered in the negative. That is in favor of the petitioner and against the department. The impugned assessment order, insofar as it imposes penalty on the petitioner, is hereby set, as are the corresponding orders of the first appellate authority and the tribunal. The revision petition is allowed in the terms.
Item 18.
May I please, my lord? This honorable court already admitted the matter on 10/11/2015. Now it's covered by the case of automobile, my lord.
The order sheet is there.
But there is no date, no. I'll kindly have a glance to the question of law admitted, my lord.
Correct.
Whether in the past also.
On 10th November 2015, the following question is framed to the court for consideration. Please produce a question. Paragraph in view of the court. Got the judgment, sir, or you don't have it?
Yes. Yes, sir.
The judgment is not reported anywhere so far.
I have not gone.
So extensively relied upon in so many cases. At least tax journal should be. Judgment dated 1st December 2021 in STREB 64 of 2016, Messrs. Keshav Automobiles, State of Odisha. The question is answered in the negative, that is in favor of the petitioner dealer and against the department.
Right.
Item 19.
The revision petition is allowed in the above terms.
My lord, item
LCR
19.
be returned forthwith.
My lord, in item 19, the petitioner has a cause entry of the wooden strips, my lord, commonly known as language bitter, from outside the local area, lordships. So on that, your lordship, the honorable tribunal held that see, wooden strips are qualified to be a timber, your lordships. My lord, these are the wooden strips I have procured from the outside state of Orissa, and on which entry tax has been demanded of me, holding by the timber, your lordships.
Why is it not
there is an occasion before this honorable High Court, your lordships, to decide the issue. What is timber actually? That is in the case of Krupasun Sahu and Sons, reporting 35 STC 270, my lord. Please. I invite you to the page. Sorry. Para 6, my lord. Page 2 of my lord. I may permitted read out, my lord. Yes. Befit of authorities, we propose to analyze the meaning of the word timber is understood in common parlance, specifically in commercial circle. It is to be emphasized that all the wood is not timber, though timber is wood. In common parlance, timber ordinarily means long wood or wood used for purpose of beams and pillars in the construction of house and such similar uses. After felling the big trees and the chopping of the branches of these trees, the trunk of the trees is called timber. A very long piece of log may be cut into different pieces. If the pieces are cutting still remain long, so it is to be used as beams, pillars, and such similar uses, the cut pieces would still be called as timber. To illustrate, a timber originally 60 feet long is cut to 3 pieces of 20 feet each. Each of these 3 pieces retain the sufficient length to be termed as beams, to be used as beams or pillars, and would be still treated as a timber in common parlance. Take another illustration. After purchase of some timber, a dealer, for the sake of convenience and transport, may cut a portion of each end of the timber, may fill up bags and polish the joint at the same places of those timber.
I think that next page, that last paragraph is enough. Thus, timber in common parlance in Orissa.
Yes, my lord. Right. Thus,
what do you say, sir?
Finding of the tribunal as page 26. I'm just reading out. However, as claimed by the dealer that they have purchased bitter only is far from truth, and the observation of the learned JCST not to impose entry tax on the purchase value of bitter as the same is not scheduled good is also not justified. As per the meaning of the timber as indicated above, since bitter are used variously, such as in tools, sieves and fences, etc., and as per Webster, timber would include all sorts of wood from which any useful article may be made or which may be used to advantage in any class or manufacture or construction. Therefore, as part of the above meaning, bitter are nothing but timber.
No, but this Kripa Sandhu's, this judgment is not referred to. This is a 1974 judgment.
No, my lord, that has not been.
My lord, 1975, my son.
That has not been referred.
Report in 1975 STC, 35 STC.
While admitting this revision petition on 31st July 2015, the following question was framed for consideration. You produce a question. Paragraph, the above question, admittedly, the petitioner purchased single quotes bitta, which is a small wooden stick. Stop. The question was whether that stick could be considered to be single quotes timber. Unquote, for the purposes of entry 41 of part 1 of the schedule to the OET Act. Question mark. Paragraph, the questions have been answered in favor of the dealer and against the department by this court in the context of section 5, bracket 2, bracket capital A, bracket small 2 of the Orissa Sales Tax Act 1947. In Kripa Sindhu Sahu versus State of Orissa, 35 STC 270 bracket ORI. To stop the said decision, this court the meaning of the word single quotes timber and held as under 8A. Paragraph it seemed that the tribunal had no patience and did not somehow refer to the above decision, which was obviously binding on the tribunal. Inasmuch as the single quotes beta does not answer the description of timber, as would in common parlance in Orissa, as explained in Kripa Sindhu Sahu and Sons versus State of Orissa, Supra. The question is answered in the negative, that is in favor of the SSC dealer and against the department. The impugned judgment of the tribunal is accordingly set aside. The revision petition is allowed. No order is to pass.
Item 20.
Please, your lordship, my lord. My lord, this revision has been admitted on the question of law, my lord.
Wheat bran or choke will be exempted. I think we have answered this question. No?
My lord, if it is sold as cattle feed, then it is exempted. When it's sold as husk, choker, then it is taxable. That is the finding of the flora below and the tribunal.
We've decided this issue, sir. Only a few months ago we decided this. We've decided this. Are you aware, sir?
Yes, my lord, I'm ready. I'm submitting, my lord.
Are you aware of our judgment, which we passed 2 months ago on this very issue?
My lord, I am hearing problems. My lord, question is, my lord.
Are you aware of the judgment we have delivered 2 months ago on this very issue?
Sorry, my lord. Sorry, my lord. My lord.
All right. Counsel for the petitioner as well as the department need some time to ascertain if the question already stands decided by a decision of this court. Which year is this to have? List on 22nd February. We'll see. It's covered. There is
27?
22nd February.
26th February. 22nd February. My lord, 22nd February, your lordship.
Yes, please. In the miscellaneous board.
Item 21.
Item 21, my name appearing in the cause list may be deleted.
All right.
21 and 22.
Or name shall be deleted.
Yes.
My lord,
in this
28,000.
8,000?
28.
Nothing.
In this case, the question admitted was that the
only all right, so the tax effect is very minimal. In view of the insignificant tax
continues, there will be a recurring effect because the petitioner is
leave the question open whenever the court declines to answer the questions as framed and leaves them open for decision in some other appropriate case. The LCRs be returned to petition satisfactory.
22.
Same.
23.
23, my lord, case Mr. Arpikar.
All right, stay on board.
He has other cases.
As when we call out, we'll say.
24.
24, lordship, kindly see the order dated 2/3/2017. Two question has been admitted. Whether on the fact and second the case, the tribunal justified to hold that cash discount oblique incentive which are given in accordance to regular trade practice not issuable. And second was is whether fact and second they are justified to hold cash discount incentive got annually is not permissible deduction under section 246 of the overhead Act. The lordship has already decided this issue. So C8 and Sun Pharmaceutical. And if first appellate authority is my favor, it is allowed. Tribunal is not change the view and it cannot be allowed.
All right. On 2nd March 2017, the following questions were framed by this court for consideration. Reproduce questions. In view of the decision dated 6 July 2022 of this court in STRE 25/2013, bracket Messrs. Sun Pharmaceuticals Industries Limited, the state of Orissa.
Question number A.
Question A is answered in the negative, that is in favor of the SSC dealer, bracket petitioner, and against the department. What about question 2?
Question 2 is related because if it is not common as sale price, then if you allowed the question number 1, then question number is not need not be.
Yeah, in view of the answer to question A, question B need not be answered. The revision petition is discussed.
25.
Please, my lords. My lord, different question of law, whether on the facts of the case, the input tax credit being a substantive provisions under the OBT Act cannot be disallowed for procedural irregularity of claiming the same through retail invoice. Next question, whether on the facts and in circumstance of the case, appropriate value-added tax having been charged separately on the body of the retail invoice and the transaction being genuine transactions between 10 dealers, input tax credit cannot be disallowed. Even
So if
claim
you do not claim ITC in the retail invoice, can you still claim it as a question?
53,000 impact. 53,000 impact.
My lord, the beginning era of the OBT Act. Introduction of the OBT Act.
Decided in other years.
My lord, categorical finding is the tribunal, my lord, we see. May kindly see.
Tax effect is
my lord, categorical finding, my lord, see, paste.
It's all right. In view of the insignificant tax effect, the court is not inclined to entertain the present revision petition. Leaving the questions open for the decision, some other appropriate case, the petition is disposed.
Item 26.
26 also 52,000.
No, my lord, the sub item that is ET, my lord, the VAT item is 43, STRB 43, the sub item. That is more than 2 lakhs, my lord. My lord, Kundap law admitted on 5th January 2016, my lord. Whether in the first and second of the case, the tribunal was legally correct without proper verification of details produced, held that the dealer had not produced any evidence on the business transaction and alleged that the purchase suppression was not accounted in the books of account, even though was not confronted to arrive at a quantity suppression, if any made. And the second question, my lord, whether in the facts and circumstances of the case, the forum below had detected any escapement of out of returns, my lord, if any made or found in the records, except on the report of the vigilance wing, and held that the assessment is correctly made, invoking section 43 of the OVAT Act. And the third question, my lord, whether in the facts and circumstances of the case, the imposition of penalty under 43(2) of the OVAT Act is legally valid when the entire transaction were reflected in the quarterly returns, audited books of account, and no discrepancy found in it or rejected, my lord. My lord, here the Annexure 4 series, my lord. At page 24, the Hajira file before the tribunal, my lord. The documents submitted, these are the 7 documents were submitted, my lord, along with the written submission, without considering, and the return, quarterly return already reflected. There is only allegation that, my lord, there is a purchase suppression. But already all the reflected, my lord, that audit wings visited on January 2013, my lord, 18 January 2013. And the quarterly return, the September 12, and all these returns all disclose all the entire transaction. That was not confronted by the lower authority, my lord, not assessing authority, not the first authority or tribunal, my lord. Only on the basis of that report, they are rejecting our contents, my lord. And the tribunal
and I am relying a decision of this honorable court, my lord. The tribunal have to give a definite conclusion on each and every point raised by the
There's no decision of the tribunal in this.
Tribunal have not given any finding, only supported the first appellate authority and will have against the para 7 of the tribunal, that is the para 7 and 14
Income
page.
Tax Act, sir, what you're showing.
We had the rival contention raised to their counsel appearing for the parties, gone through the assessment record, appellate order, grounds of appeal, as well as written submission, cross objection filed, and the material available on record. In the instant case, it is seen that the assessment has been made on the basis of tax evasion report submitted by the Vigilance Division, Bhubaneswar, alleging purchase and sale of goods. The learned assessing officer analyzing the said report estimated the suppression to such rupees and against such reported by the vigilance team by taking into account the prevailing market price of the goods. And since the dealer has failed to produce the purchase and sale bills against the alleged out of account at the appropriate stage, also he failed to submit annual stock inventory to dispute the allegation of out of account purchase and sale of goods raised by the vigilance department. So kindly have that Hajira filed. I have already enclosed those accounts, my lord, at page 25, as page 24, my lord. Written submission, copy of the purchase register, copy of the sale purchase invoices, copy of sale bill, copy of VAT tax challenge, copy of PT challenge, copy of a stock inventory balance sheet and audited report certified by the chartered accountant for the year 11-12 and 12-13, my lord. These documents have to be properly verification has to be made, my lord. Thereafter, my lord, tribunal so the appellate officer confirmed the assessment in absence of valid material. Before this forum, the dealer out of account purchase and sale detected by the vigilance officer and stated that were duly accounted for in the purchase and sale register. Besides, the dealer has alleged that the vigilance team has overvalued the goods detected as out of account. The dealer stated that he has purchased wooden goods from the local unregistered carpenters through purchase voucher, which do not show the actual value of goods. Before this forum, the dealer has submitted the copy of some of the documents whose authenticity with the original is not ascertainable. We find has admitted the out of account at the stage of investigation of vigilance team. But here the submission, my lord, written submission, it was already, because the vigilance team already made signature, my lord, accounted in. We find that the dealer has admitted the out of account at the stage of investigation of vigilance team and failed to substantiate evidence to refuse the charges out of account of purchase and sale of goods at the assessment and appeal stage, for which the assessment has been confirmed. Before this forum, also he was not able to substantiate documentary evidence to refute the charges leveled against him. Moreover, production of local support of any discriminatory notice give ample scope to the dealer to set right all allegations, my lord. Without verification, without confrontation, the allegation that set right all allegation, my lord, which is in fact is not correct, my lord. Which in our opinion is now tarnished and afterthought, my lord. That is the finding of the tribunal, my lord. Hold that it is afterthought. When all these accounts and a return filed for the quarter ending March 13, how can it be afterthought, my lord?
No books of accounts shown by the dealer.
My lord, the assessment orders kindly have against the assessment order. There is no such allegation, my lord, that no books of account, my lord. Only on the basis of vigilance wing report, my lord, can have 21 page 21 last para 2. On being confronted at the time of assessment, dealer stated that firstly the goods displayed in his business place are made by the local carpenter, that he has shown such purchase from unregistered dealer in the quarter returns September 12, December 12, and March 13, totaling to an amount of such which is already placed in the record within bracket Xerox of purchase register. My lord, already accepted by the my lord. Beside that, that is the enhancement of
Same page, my lord, first, second, third, fourth, sixth para. The report is based on a surprise visit made by the business place of the dealer by the officer Bhubaneswar Vigilance Wing on 18/1/2013, when the proprietor was present and looking after the day-to-day business activities of the firm. The visiting officials recovered certain loose leaves and documents which were seized by the visiting officials. Those documents later confronted to the dealer on 24/2013, but he could not produce any.
My lord, before the submission before tribunal, my lord.
The tribunal pass the detail, right? In the listing before the tribunal, on first category, on which date the will appear to the authorization for the part.
Both item 42, stage 42 and 43, my lord. 42 is the OET Act and 43 is the OBAT Act. Obligation.
Item 27.
Honorable Justice, someone was there.
You are referring to the state.
27.
States will be.
I'm for the respondent. Honorable Justice.
Not decided by.
I have no objection.
This before a bench of which Justice Raman is not a member. On first February. Not first, we'll have it on 1st March. 1st March.
Lord's
Item 28.
My lord, I'm appearing for 28, my lord. Item 28 and 36. Issues are one and same, my lord. The issues are already framed. Only issue is imposition of penalty under section 42(5) of the OBAT Act.
Yeah.
My lord.
That's automatic, sir.
No, my lord. Let me submit, Lordship. It is not automatic, my lord.
We've already decided, sir. Are you aware of our judgment? Where's the
yes,
judgment?
my lord. Jindal, my compilation is there. Kindly see, my lord. I am confining to judgment, my lord. I am not going without judgment, my lord. Kindly see judgment of this court in Jindal. My lord, at page 100, my lord. Page 100. Page 100, my lord. Jindal judgment.
Sir, have you seen our judgment in Chandrakanta Jayantilal?
My lord, I think this, I'm not very sure about that, your lordship. But Jindal is being followed everywhere, my lord, in all the cases.
Anyway, that's up to you, sir. You take your chance. All right, all right. If you don't want to see our judgment, we cannot compel you to.
No, my lord, I don't have.
No, that's up to you, sir. We are not your law researchers. Unfortunately.
My lord, may I submit, your lordship?
No, we are not your law researchers. So you have every right to argue the way you want to, sir.
I'm sorry.
Yes. Absolutely. Yes.
Lord, kindly allow me by 5 minutes only. Page 100, my lord, kindly see.
Yes.
Judgment of this court in Jindal.
Yes.
The matter may be looked into from a different angle.
Yes.
Section 42 of the OBAT Act deals with audit assessment. As stated above, imposition of penalty is dependent upon quantum of assessed in audit assessment under Section 42 of the OBAT Act. If such a panel provision is not provided, kindly see, my lord, then fraudulent dealers would seriously venture to evade tax, and whenever they will be caught, hold, they will simply pay the tax and escape. Therefore, the provision for imposing penalty twice the amount of tax assessed under Section 42 of the OVAT Act has been made so that a dealer SSE who would refrain from himself from any step to avoid payment of legitimate tax. If, however, any dealer indulges himself in any activities to evade tax, then in addition to the tax assessed, my lord.
Yes.
Fraudulent, my lord. So only when there is a fraudulent activity, Section 42(5) will be attracted. Now, my lord, how I am saying that, I will show you in the provision, your lordship. Kindly see the provision, my lord. Kindly see the provision, my lord. On page, my lord. My lord, page 14, my lord. My lord, page 14.
Yes, sir.
My lord, page 14, kindly see, my lord. Section 42. Yes. Section 42 is to be read in its entirety. Each subsection cannot be read disjunctly, my lord. Section 42(5) is to be read in the context of 42(1), my lord. What 42(1) says, my lord, where the tax audit conducted under Section 3 of Section 41 results in the detection of suppression, my lord. My lord, pause for a while. In mens rea is inbuilt in the word suppression, or purchases, or sales, or both, earnest claim of deductions, including input tax credit, evasion of tax, or contravention of any provision of this act affecting the tax liability of the dealer. The assessing authority may, notwithstanding the fact the dealer may have been assessed under Section 39 or 40 or 43, serve on such dealer. So, my lord, it says the other words are in the company of such words as suppression and evasion. So the English words will take their color from their companion, not as sources, my lord. So these words are to be read in their companion, and then comes 42(5), my lord. If there is detection of any suppression or evasion, means there must be a fraudulent activity. That is what this court in Jindal has said. That the fraudulent dealers not paying tax. So the language of this Section 42(1) and 5 and that of Jindal is one and the same, my lord. In my case, my lord, what has happened? I calculated the ITC, reversal of ITC on my own. Department said, no, it will be more. Then I challenged that on the ground that the ITC calculated by me is in accord with Section 19 and 21. Then the learned tribunal ultimately held that there is no specific formula for calculating it. So my submission is that when there is no formula, my lord, then my formula adopted by me cannot be found to be false or incorrect. Finally, kindly see, my lord, finding of tribunal. In both the cases, the tribunal has held that there is no specific formula. Then the formula adopted by me cannot be said to be wrong. I am not on the merit because the question of issue framed before lordship is very limited to penalty. But to demonstrate that on the fact circumstances, there is no evasion of tax, there is no fraudulent activity, there is no suppression of fact. You see, my lord, the finding of tribunal in the first case, my lord, item 28 and 36, my lord, same issue. Yes, I am showing you, lordship, the finding of the tribunal, my lord. Page 55. Page 55, my lord, it reads third line. The learned counsel vehemently challenged the calculation made by the learned CST. We do not find any concrete fixed formula prescribed by the learned formula prescribed under the OVAT Act or rule on calculation of the input tax credit as well as output tax where input tax credit is surplus. What I contended, my lord, that Section 19 and 21 says that from your input tax credit, first you will deduct the tax under the OVAT Act. Then whatever is left out, with that you will deduct the CST liability. Then whatever is left out, that you will carry forward. This is what law says. But what the authority did here, they from the input tax credit, they first deducted the reversal, the CST liability, then the closing balance of input tax credit, my lord. Carry forward closing balance. From the balance, they deducted the OVAT Act, the liability under the OVAT Act. So it is contrary to 1921. So in any case, my lord, I am not on merit on this this question framed by your lordship. But the thing is that when the tribunal itself admitting that there is no concrete formula, then the formula adopted by me cannot be said to be false or not reasonable. And that being the case, there is no case of any evasion, fraud, or suppression, anything, my lord. That being the case, my lord, even applying the principles laid down by the Supreme Court, this honorable court in Jindal, the penalty cannot be levied on me under 42(5), my lord. And my lord, kindly, one judgment I would like to show you, lordship. In the comparison, my lord, page 43 may kindly be seen. Page 43. Page 43, para 19. It is the case of, my lord, Supreme Court in versus Muhammad Hussain, State of AP versus Muhammad Hussain. Kindly see, my lord, page 19. We cannot ignore that it is well settled canon of interpretation that when it comes to construction of a section, it is to be read in its entirety, and its subsection are to be read in relation to each other and not disjunctively. My lord.
No, this is a criminal.
My lord, in any case, my lord, then one judgment of Supreme Court in the case of, my lord, tax matter, Puspam Pharmaceutical, 63, my lord. Page 63. My lord, page 63, para 4, my lord. Last 4-5 lines, my lord. Para 4, last 4-5 lines. A perusal of the proviso indicates that it has been used in company of such strong words as fraud, collusion, or willful default. In fact, it is the mildest expression used in the proviso. At the surroundings in which it has been used, it has to be construed strictly. It does not mean any omission. The act must be deliberate. In taxation, it can have only one meaning, that the correct information was not disclosed deliberately to escape from payment of duty. So, my lord, the other words in the company of the word suppression, evasion of tax, will take its color from its companion. And that being so, my lord, unless there is a deliberate defiance of law, that's what the court has held in the case of Jindal, that only fraudulent delays can be punished under 42(5). In this case, when the tribunal has held that there is no fixed formula, then applying my own formula, I reversed any extra tax liability I have already paid, cannot impose, my lord.
Both the revision petitions are dismissed. The question is answered in favor of the department and against the dealer. We pass the detailed order. I'll pass it.
My lord.
Item 29.
So that is 27 and 36, no?
My lord, 29, 37, my lord, I am respondent, my lord.
28 and 36. All right.
Item 29.
29, my lord, case revision. The question already admitted on 3rd February 2016 by this honorable court that whether on the facts and in the circumstances of the case, the conclusion of the Learned Orissa Sales Tax Tribunal is fallacious as it held that exclusive used in the blasting for extraction of mineral would fall within the scope of definition input contained in section 225 of the Orissa Value Added Tax. Here, my lord, the respondent is a miner who get minerals by exploding the mines by using explosives. The assessing authority.
This is like coal being used for generating electricity. Same principle.
It is not consumable. So it's just blasting the mine.
Coal for electricity. What was the decision in that? That's gone up to the Supreme Court.
Yes, my lord.
Coal being used for electricity. Still pending.
Yes, ma'am.
All that is pending. That coal being used for electricity. You're not there in this matter. Who's Mr. Kurmi? You're appearing in this.
My lord, in this matter, my lord, as you can see, National Aluminium and Reliance Industries. These two
both are pending the Supreme Court.
That my lord is.
Both are pending the Supreme Court. Yeah. You say considering that the questions that have been framed in these revision petitions, we'll have to await the judgment of the Supreme Court in certain similar matters arising from the appeals filed by the state against the judgment of this court in, I guess that citation,
One is my lord Reliance Industries 6 number item, and my lord National Aluminium 8 number item in the compilation, my lord.
Which compilation? Arising out of the decisions of this court, and Reliance Industries versus Limited versus ACST 2008-15 VST 228 bracket Orissa, and National Aluminium Company Limited versus DCCT 2012-56 VST 68 bracket Orissa. The present revision are directed to be listed after disposal by the Supreme Court of the aforementioned matters. Liberty is granted to the parties to mention the listing after the judgment of the Supreme Court. All right. I think we should take a break.
Obliged, my lord.
You're taking a break. Taking a break.